Very well.
Yes.
Validity, I beg to mention item number 7 and 8.
7 and 8.
Yes. Can it be taken up to 4 weeks? Because in other matter, Mr. Tony Partin has also requested. In other matter, Tony Partin has requested. I'm at item number 7 and he is at item number 8.
Some ancestral land was
Yes,
decided.
yes. It has come back from Supreme Court.
Oh. As prayed for by Mr. Saxena, Kamal Saxena, K. Saxena. List the matter after
4 weeks.
4 weeks.
Obligation.
Consent you have taken? Right?
With both consent and date.
Okay. As prayed for by both the parties.
May my lordship, I beg to mention item number 22.
22.
Hearing matter.
One
In
second.
this, record was called for, my lordship, but we
Yes.
haven't received. Records were called for.
Records were called for, not received.
So this matter is listed after 2 weeks.
Miss, you are for the bid
Government.
appellate? Oh, you're for the government, yes. Miss
K. Wang.
K. Wang. B. Counsel appearing for the government, and the government advocate states before this court that the records which were called for has not been received till date. As such, she prays for some time. The prayer is allowed. List the matter after 2 weeks or after the vacation? After 3 weeks. After 3 weeks. Yes, Mr.
As regard item number 21.
20.
21.
21. Okay.
I may be allowed, it may be upgraded, your lordship, because from the last 3 times, if time permits, madam, because
Okay.
it will take some time.
Otherwise, this is an order matter.
Order, but it will take, I have to, for taking order, madam, I have to place.
Acha.
That's right.
Okay.
If time permits, madam, it may be upgraded.
Otherwise, the court is rising at 2:45 today.
That's why.
Okay, it can be taken up.
Other
Let's
matters are not urgent, this is very urgent.
Acha. So it can be taken up. Let it be called after motion. Okay.
21.
I'm 21.
My lord, one regular bail is being filed this morning. My lord, the service order person is my lord in the custody. So my lord, CD is only to be called for one. So I'm praying for taking up the matter as a today's unlisted man.
It's a bail application.
Bail application.
He is inside.
Yes.
What is the urgency? We can take it up on Monday.
My lord, at least my lord, if the CD will be called for my lord, then the final hearing will be Monday or Tuesday. So my lord, CD.
It's okay. Monday, let it be listed. And then we can hear it on Wednesday. Okay. Monday, list the matter. Oh.
May I please, Lordship? Lordship, I beg to mention item number 18.
18.
On behalf of Mr. Akram Hussain, who is the petitioner counsel, who is out of the station.
This is an order matter. We can see why it is listed and then.
Lordship, actually, the day before yesterday also, this same matter, which arising out of same case, has been listed in item number 16. Yesterday it got adjourned. So same that may be given.
Acha, that's an analogous.
Yes.
When was it
So
fixed?
we may be clubbed together. It may be fixed on
In what way it is?
22nd July.
Sometimes what happens, we tag matters and
Yes.
then we find out that no, these are all different.
Yes.
And then we have to again retag it. So how it is related to each other?
It is arising out of same matter only, same case. Lordship.
Same case.
Yes.
This is a revision.
Yes, revision petition.
Again, some order.
Yes, some order.
What do you say? Is it same?
Yes, Lordship. Actually, yesterday matter could not reach Lordship, scarcity of time, Lordship. So yesterday this petitioner side prayed to list on.
No. I took adjourned. Yesterday it was reached.
Any date
Yesterday
fixed in
matter.
that matter?
Yes, 22nd July.
Or 22nd.
It was fixed on 22nd July.
Listed together, Lordship.
Yeah,
It is
together.
stated by Swans in item number 18. No? It is stated by Swans that you're for the petitioner.
Yes.
Yeah, appearing for the petitioner that a similar matter was listed on 26th of June 2025 and the same was directed to be listed on
22nd
22nd
July.
July 2025. He as such prays that this matter may also be listed along with the said matter and fix it on 22nd of July. Prayer is allowed. Let both the matters be listed together.
Lordship, also there is an IA. One IA is also there.
I is there.
Yes,
Then
yes.
all will come together.
Yeah,
So let the matter be listed together on so and so.
Like,
obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 13 and 14.
13, 14.
13, 14. This is a petition for quashing of FIR. Lordship, I'm not in a position to argue this matter today. So can it be taken up on Monday? I'm told the CD has come.
Okay. As prayed for by Ms. N. Dungan, list the matter on Monday.
Yes, obliged.
Your Lordship, I'm for the I on behalf of K. Taso, on behalf of respondent number 2.
Which matter?
I like to mention item number 11 for
11.
adjournment because he could not present today. He is out of station. And meantime, we were allowed to file affidavit in opposition.
It is prayed by Ms. So-and-so that the conducting counsel, you are for the petitioner?
No, I'm for the respondent number 2.
Appearing for respondent number so-and-so. You have taken consent from the
Yes, Your Lordship.
it is prayed that she needs some time to file the affidavit in opposition.
Yes, Your Lordship.
What affidavit in opposition and revision?
Senior
You file
has.
some additional affidavit.
Okay.
Okay, file additional affidavit and as such has prayed for some time. List the matter again on.
Counsel for the petitioner has purpose for the 31st of July.
List the matter on 31st of July as agreed upon by both the parties.
Developed.
May I, Lordship? Lordship, with the consent of opposite party, I beg to mention item number 23, Lordship.
23.
Yes, Lordship.
It's a hearing matter.
Yes,
My lord,
Lordship.
yes, hearing matter, my lord, I am appearing in this case, my lord, for the petitioner.
Okay. Yes. So there is a prayer for adjournment today.
Yeah, yes, my lord, they have taken consent.
So
After 4
Yeah.
weeks, my lord.
yeah,
After
you come
4
after
weeks.
the vacation. Yes. As prayed for by Mr.
T Tato.
T. Tagum.
T Tato on behalf of T Tagum.
On behalf of T. Tagum, list the matter after 4 weeks. Mr. B.K. Singh is also present. Just write that name. Okay. After 4
Oblige,
weeks.
my lord. Oblige.
On a date to be fixed by the registry.
Yeah, yes, my lord.
Oblige, Lordship.
Oblige.
Okay, Lordship. Lordship, I would like to mention item number 12. The matter
12.
12, yes.
Okay.
The matter may be adjourned for today as the leading counsel is out of station.
It is stated by
T.
Mr.
Pumbo.
T. Pumbo.
Pumbo, yes.
T. Pumbo for the learned counsel appearing for the petitioner. That the conducting counsel is out of station.
Yes,
Mr. D.
Lordship.
Saikia.
D. Saikia.
That states that the conducting counsel is out of station and as such he has prayed for some time. List the matter
And-
after 2 weeks.
Yes, Lordship. And your Lordship, the interim may be continued. Yes,
Interim
interim.
passed earlier shall continue till the next date.
Much obliged.
My lord, this is civil division petition, my lord.
Against the decision of Kebang.
Yes, my lord, this
So many matters I see now, this against the decision.
against my lord, basically the system is like that. If the dispute is in between the parties who are from same village, then that dispute will be taken up by the Gambura of that village.
This is what is stated before also.
Yes.
They don't have jurisdiction where persons stay somewhere else.
Yes, yes, my lord.
Here they are not staying in that same village.
Well, they are from same village.
They are from same village.
Yes.
Then what is the wrong in Kebang's order?
That is because after, if someone is aggrieved by the decision of village level Kaba, one has to prepare appeal before that Bango level Kaba, that particular area.
Bango.
Yes, Bangalore.
Is it provided in the Civil Courts Act?
Yes,
2021?
yes, madam. Inter-village customary court. It is written like that in the Civil Court Act. So inter-village consists of, it can be this consisting of more than 2-3 villages. This particular petitioner and the respondent, they are from Sago village, and Sago has its own this inter-village customary court.
Acha. Okay.
This dispute, the cover decision of the Sago village ought to have been appealed before the Sago circle, not before the Basar circle. Basar is distinct and separate circle. My lord.
Basar is different circle.
Yes, yes.
And this, the other place you said what?
Sago circle, yes.
Oh, Sago.
Yes.
Sago is different. But then you said that 2-3 villages, there are what?
Yeah, inter-village customary court is there.
In
So,
respect of 2-3 villages.
Yes, yes. Sago itself is a village and it is also a circle consisting of more than 5 villages.
Consisting of more than 5 villages.
5 villages, yes.
Sago.
Yes, that constitute Sago circle. So both these petitioner and respondents, they are from Sago village and they are within the jurisdiction of Sago circle, not within the jurisdiction of Basar circle. It is separate circle, madam.
But what? They have made the appeal before Basar?
Yes, yes, madam. So my lord can see from the records itself, my lord. Even the deputy commissioner, my lord. Page
The
number 4.
appeal before the deputy commissioner is gone after this as Court Act had come into force?
Yes, yes, my lord.
Earlier it was before DC?
Earlier it was before DC, yes. It was before DC.
Okay.
Earlier this is as per section 46, which has been my lord, repealed. And this Civil Code Act, my lord, from 2021 to 2023, there has been 3 amendments, my lord.
Okay.
So after the amendment was made into the Civil Code Act, my lord, the jurisdiction of deputy commissioner has been done away with. Yes.
1 year it is said.
Yes, yes,
If
madam.
he cannot dispose
Yes.
within 1 year,
Yes,
then we
madam.
have to
Yes, madam.
transfer it.
Yes, my lord.
So here what is the problem?
The problem is, my lord, problem is that, my lord, I have a decision, Kabat village decision in my favor. Earlier, my lord, the
Every party went and filed an appeal before the Sabar Council.
my lord, may I submit, my lord? My lord, the fact of the case is like this. As I have stated, my lord, the petitioner and the respondent, they are from same village and same circle, which is Sago circle. Earlier, what happened, my lord? The dispute between the petitioner and respondent, that was decided by the inter-village customary court of Sago circle, my lord. That decision, my lord, that was put to challenge before this honorable court, saying that
Before this honorable court?
yes, my lord, before this honorable court by the respondent, because as the decision was made in my favor, so the
First
respondent.
they have to file an appeal before the what? Some authority in Sago circle?
Yes, yes, my lord.
They did it.
No, my lord. No, my lord. There is this inter-village Keva decision.
That is Keba
Yes,
decision.
yes, inter-village Keva decision. That means, my lord, the Keva decision which is made by this Sago circle, my lord. Sago circle, not the Sago village. So the contention before this honorable court was that before conducting a village level Keva, the Sago circle could not have taken the matter because it lacks original jurisdiction. The dispute has to be first settled and decided by the village level Keva. So it was not done, but the Keva, it was inter-village Keva, which has rendered the decision in my favor. So that inter-village Keva decision by the Sago circle, Sago Bango, that was put to challenge by this honorable court, contending that no, that could not have been done because the dispute ought to have been decided by the village level Keva first. Because Sago circle lacks the original jurisdiction. They will take up the matter in the capacity of appellate authority. So that contention was held correct by this honorable court. So therefore, village level cover was subsequently conducted. That Bangor level cover by the Sago circle was set aside and fresh village level cover was conducted by the Sago village authority. In the decision, in the cover decision, it was rendered in my favor. Now, being agreed by that decision of Sago village, the respondent, he took up the matter before the deputy commissioner. Deputy commissioner, even he has observed that the Basar circle, Bangor, do not have the jurisdiction as the matter pertains to within the jurisdiction of Sago circle. That observation, my lord, may kindly come to page number 41.
Yes,
This, in fact, is the filed notice, my lord.
this is appeal original Kiba decision.
Yes, my lord. My lord, may kindly instead of come to the bottom.
Wait, let me go through the first part.
Yes, yes.
The facts of the case. Just see the 5 lines from the bottom in the first paragraph. This, what is HGB? Deputy Commissioner has
Head Gambura.
head Gambura.
Yes.
Said appeal was forwarded to head Gambura of village so and so. Then what do you want to place from here?
My lord, my lord, may kindly come to the bottom part, my lord. My lord, will see. Sago is separate and distinct administrative circle. As such, endorse the case to CO Sago to convene and inter-village open derby to settle the dispute amicably till such pendency or like that, my lord. Someone of HGB Gori be kept in call.
And where this is passed by whom?
Yeah.
This order?
This order is in charge deputy commissioner. So, my lord, from here, my lord, itself it is very clear that Sago is a distinct and separate administrative circle.
Yes.
So, therefore, if anyone is aggrieved by the Kaba decision of that particular village, which is Sago village, my lord, he ought to have prepared the appeal before the Sago circle, my lord, not the Basar circle, my lord. There are 4 circles in entered Leparara district, my lord. That is, my lord, Rego circle, which Rego circle is
Now today it has come up for the first time, right?
my lord.
Today it has come up for the first time. Just for motion, yes. The matter.
Yes, my lord.
And then let notice go to the person, right?
My lord, I have an interim prayer too, my lord.
You have an interim prayer.
Yes, my lord.
For stay of what?
Stay of the Kaba decision, my lord.
There's no interim prayer, my lordship.
Hmm?
There's no interim prayer.
There is interim prayer.
There's no.
In my copy it is, there are.
interim prayer.
Maybe your copy does not have.
Yeah, I only supplied the fresh copy, my lord.
Ah,
That
you
is,
supplied
if
the
fresh
fresh
is
copy.
then.
Heard Mr. So-and-so. You are only on the ground of this
Jurisdiction
no
around.
jurisdiction.
Yes, my lord. Lack of jurisdiction, my lord.
Heard Mr. You are Dumbar Kambo.
Yes, my lord.
Heard Mr. Dumbar Kambo for the petitioner, as well as K. Wangmu, government advocate. This is a petition filed challenging the order dated Keba decision or order, it's okay. Challenging the order dated 10/5/2025 passed by the Inter-Village Territorial Customary Court, Basar, Lemprada District, Arunachal Pradesh. Mainly on the ground that the said customary court, Basar, has no jurisdiction to entertain, to pass the said order. He has also challenged, you have also challenged another order.
Yes, that is
24/3.
16/5/2025, my lord, whereby the C. Okay. Oh.
No, 24/3.
Yes, yes, sorry,
The
24/3, yes, my
petitioner
lord.
is also challenged the order dated 24/3/2025 issued by the circle officer, Sago, whereby he has directed the district customary court of
Basar.
this is Basar, right? But then Basar is not written. Lemprada. Anyway, that is Basar, I think, to conduct the Bango level Keba instead of directing the Sago circle to conduct the same. The counsel appearing for the petitioner states that as per the law, states that both the petitioner and the respondents are inhabitants of Sago circle,
Sago village, my lord.
Sago village.
And circle as well, my lord.
Sago village within the Sago circle.
Yes, my lord. Exactly.
And the Keba was also of Basar. The decision?
Yes, my lord. Yes. Keba, village level Keba was for, by the Sago village, my lord.
But appeal was.
Appeal was, yes, my lord. From
Before.
Basar, my
He stated that both resides in the within so-and-so, and the Keba decision was passed by the Sago, Sago circle. Keba decision was passed by the
Sago village, village authority of Sago village.
Village authority of Sago village.
Yes.
However, the appeal by the aggrieved party was filed before the Inter-Village Territorial Customary Court of Basar. Right?
Yes, madam.
Basar circle, which has no jurisdiction, according to the learned counsel. Appeal decision, you have said this one, no? I mean, issue notice to respondent number 2. So K. Wangmu appears for respondent number 1. So no formal notice is required to be served upon her. However, extra copies may be served on her within the day, during the day.
My lord.
Issue notice to respondent number 2. Where is the law under the so-and-so that same circle will hear?
Yes, my lord, that is.
It is in the District Court Act.
That is, my lord, the Civil Code Amendment of 2022, my lord.
Yes.
And my lord, it is also provided in the amendment of 2023 as well, my lord.
Just pass me that.
Yes, my lord.
It's not annexed with the petition, right?
My lord, I have categorically mentioned in the petition.
Acha. Okay. But then just, where did you mention? It's in the pleadings?
Yeah, my lord. In my petition, my lord. And so, my lord. 9. My lord, para 10, my lord.
Which amendment?
That is 2022 amendment,
Ah,
my lord,
which-
serial number 9, my lord.
By virtue of amendment to section 24. By virtue of amendment to section 24, by Assam Frontier Administration of Justice. This is not Civil Court Act. Acha, the amendment is here.
Yes, ma'am.
By virtue of so and so of section 24 of Assam Frontier Administration of Justice within bracket Regulation Amendment Act 2023. It is provided that any party aggrieved by a decision of the village authority may file an appeal within 30 days before the Inter-Village Territorial Customary Court or Apex Customary Court by whatever name called, and the said court, on receipt of such appeal, shall dispose of the case. However, in the instant case, it is noticed there is a proviso, if agreed by the parties, desires to, as the case may be an appeal arising out of the village authority or inter-village, the case may shall lie to the court of judicial district proceedings. So what did I say? It is noticed. It is noticed that the aggrieved party, instead of filing the appeal before the Inter-Village Territorial Customary Court of the said circle,
Sago circle, my lord.
of the said Sago circle, they filed it before the Basa, right?
Yes, ma'am.
They filed it where?
Basar, my lord. Basar, sir.
That is also called the Territorial Customary Court.
Yes, my lord.
They filed it before the Inter-Village Territorial Customary Court of Basar.
Yes, ma'am.
In view of the same, which is not according to the law laid down. That has to be again examined properly.
Yes.
Prima facie, what
Yes.
I see is
Yes.
this. Write the word prima facie. Oh, no. After this, okay. Which is not according to the law. As such, this court in the interim, on a prima facie examination of the aforesaid issue, suspends the operation of the KEBA decision dated 10/5/2025.
Yes, ma'am.
This is KEBA decision. This is Basar KEBA decision.
Yes, my lord. Yes, my lord.
You have NX, right?
Page number 55, my lord. 56. That copy over.
Where is that?
56, my lord. Page number 56. Annex of 15.
Village Sago, District Basar. Acha. Where is that page?
Page is, my lord, 56, my lord. Inter-Village Territorial Customary Court of.
Page 56.
Yes, my lord.
Inter-Village Territorial Customary Court Basar. Okay. Prima facie suspense. The order dated 10/5. Where is the date of the order? 10/5/2025. Passed by the Inter-Village Territorial Customary Court Basar till the next returnable date.
Much obliged.
list the matter after 3 weeks.
Much obliged.
You can take this amendment. Yesterday, I saw an amendment in section 15 also. That was in respect of civil court
Yes,
side.
yes, madam. My lord, in the 2022 amendment, my lord,
Ah,
it was provided that if the party is agreeable, then only they can approach the customary court.
ah,
But that has been done away by the subsequent amendment of 2023. Now,
23.
this agreed person,
Ah,
even without the consent of other party, can move the customary court.
oh. I'll have to go deeper into this.
Yes.
I don't know, I'm not aware. You can take the.
Yes.
May I please, my lord?
Yes.
My lord, this AB is arising out of the Itanagar PS case number 88 of 2025. And
Which is the offense, 61(2) is?
my lord is granted pre-arrest bail.
Chachi Namlam,
My lord.
that those ladies and all.
My lord, my name is not there in the FIR.
Ah,
But I'm apprehending arrest because I was a witness to that scuffle between the wife and that lady.
you were among those unidentified persons?
Yes.
And you were also coming together with the other 4 ladies?
Yes, ma'am.
After seeing some land shed?
Yes, ma'am. My lord,
Why are you apprehending?
I'm a nursing officer, government servant. Moreover, I have 5 minor kids. So, my lord,
Your name is?
Srimati Tongchi Lamgu Flago.
Sri Lanka. Okay. Why are you apprehending where? Where are you pleading that police are searching you?
My lord, my case is paragraph number 8 of my petition. Para 8.
Where you served with any that notice?
Not
41
yet.
notice?
Not yet.
Not yet. Paragraph?
Paragraph 5. I have admitted myself that the applicant begs to state that the informant and the one of the co-accused, Srimati Chachi Nablam Lamgu, along with her husband, had entered into mutual settlement agreement upon the intervention of family members. And as per the agreement, the present informant had agreed not to continue her illicit affairs with the husband of the present applicant. However, while the co-accused person, Srimati so-and-so, and the present applicant was traveling to Poma, along with some other relatives who have been made co-accused in the instant FIR, Srimati Chachi Namlam saw the informant meeting her husband at Niti Vihar, Itanagar. As such, she got infuriated and confronted with the informant, and minor scuffle ensued, which is clearly recorded in the CCTV installed in the said area. The applicant is just a witness to the entire episode that transpired on that fateful day. So, on this pretext, the police may, someone may call me for interrogation. And I being a government servant in the case of arrest, and if I be there for 24 hours, my service
You
record.
have the call for interrogation?
Not yet.
So?
Lordship, Lordship here, Lordship. Now,
She was not even named in the FIR. She
but,
was
My lord.
but the other unidentified person, she may be Lordship.
Yes.
And she is within one of them.
I've admitted, my lord. That is what I'm witness to the scuffle.
Case study may be called for. We'll see the whether case study his how
study-
much his involvement is there, Lordship. Then till that Lordship, no interim.
Interim.
Lordship.
My lord, the main
So that-
accused has also been granted interim by this honorable.
Since
Lordship, the interim last occasion it was granted just because the minor baby is a lactating mother, Lordship. On the death, not only this honorable court has granted bail, but in this case, this is
No,
not there.
on
Lordship.
25th also, my lord has granted interim to the other accused. This one.
and the year was chopped off, right? This is the case.
Yes,
Where
Lordship.
the year was chopped off.
Yes, Lordship, that is also there. The medical, we have to see the injury report, Lordship.
Okay, bring the case diary.
Yes,
But
sir.
till then, since she is similarly situated,
My lord.
parity comes.
Exactly,
And
my lord. Correctly
Yeah.
also. The other matters are listed on 22nd of July,
22nd of July.
my lord.
Okay. You're right. Heard, Mr.
Then
HK
lordship, in
Jamo.
that case, he may appear and give a statement,
Yes,
lordship.
yes.
Yes.
He will appear with
Yes,
so
Lordship.
and so, I'll give those directions.
Yes, lordship.
As it was given in respect of others.
Yes, lordship.
5 days I've given in other.
Yes,
cases, so
Lordship.
he will go in. So heard Mr. So and so, learned counsel for the petitioner. And Miss yes, Lakshmi Hage for the learned additional public prosecutor for the state of Arunachal Pradesh. The instant petition is filed under section 482, right? Under section 482 of the BNSS 2023, praying for grant of pre-arrest bail to the applicant in connection with Itanagar Police Station case number 88 of 2025, registered under section 126 or registered under section 61(2). And I think it was registered under 61(2), but later in the format, I don't find this section. See the format of the FIR. That 61(2) is not there. What is 61(2)?
Criminal conspiracy, lordship.
Criminal intention.
Yes, lordship.
But I think in the format of the FIR where they fill up the blank portions, just see. It's not annexed. It's not annexed by you.
Not anything.
Okay, 61(2)/126 within bracket 2, subsection 2, and 118 subsection 2 of the BNS 2023. The prosecution story as stated in the FIR, same FIR, right?
Same FIR.
As stated in the FIR, Ms. Mahaki, you can take down from that order. As stated in the FIR dated 24/5/2025 is that
Yes.
on the same day at around 3 to 4 p.m. at Gomba Road, Itanagar, 4 accused persons along with 3 unidentified persons physically assaulted physically assaulted the informant with deadly weapon such as local made dao and knife. It is also alleged that the accused persons surrounded, threatened, and chopped off the right ear of the informant without any provocation. The FIR also reveals that the incident was witnessed by other persons and that the accused persons, after beating her mercilessly, took her bag and mobile phone. It is stated by the counsel appearing for the petitioner that the applicant is one among the 3 unidentified persons mentioned in the FIR. On receipt of the said FIR, police registered the case under the aforesaid sections and investigated the case. H.K. Jammu, right? Mr.
Right.
S.K. Jammu, appearing for the applicant, submits that the petitioner has no involvement in the said incident as lady, right?
Yes.
As she was simply accompanying the other 4 named accused persons who had gone to some place for some business purpose. He also stated that the entire incident was due to the illicit relationship between the informant and husband of one of the accused, namely Chachi Nablam Lamgu. He has pleaded in paragraph 5 of the petition that when the co-accused persons and others were traveling to some place with some relatives, co-accused, namely Chachi Nablam, saw the informant meeting her husband, and on getting infuriated, she confronted them and there was a scuffle. And that the applicant is just a witness to the entire episode. This is all.
Yes.
Ms. Lakshmi Hage, the Additional Public Prosecutor, states that the present incident reveals a serious offense inasmuch as the right ear of the informant was chopped off, as stated in the FIR. She has such praise that she may be allowed to go through the medical report and to find out from the records as to who had committed the said act. She has such praise that the case diary may be called for to get the real fact of the entire incident. It is noticed from the FIR that no specific act is attributed to any of the accused person, much less the unidentified persons, amongst whom the applicant is stated to be one. It is simply stated in the said FIR that when all the co-accused persons as well as the identified persons were coming together, and on their way, when co-accused Chachi Nablam Langu saw her husband with the informant, the situation worsened and there was a scuffle between the parties, which led to the injury as stated upon the informant. In absence of who had assaulted the victim or who had inflicted the physical harm upon the victim, this court enlarges the applicant namely Srimati Tongchi Lamdu Flago, on interim bail. As such, the applicant be released on interim pre-arrest bail upon furnishing a bail bond of rupees 20,000 with one surety of like amount to the satisfaction of the investigating officer of the Itanagar Police Station, Arunachal Pradesh. The bail is, however, subjected to the following conditions. One, the accused will appear before the investigating officer within 5 days from today and would give her statement. Two, the accused applicant shall make herself available. Hey, where have you written that police has come to your place and
No, I have not submitted. I have the apprehension because I was a witness to that incident, my lord. The police has not come to me, my lord.
Acha, in one of the places you write, Mr.
HK Jamo, my lord.
Submits before this court that although the name of the applicant does not find place in the copy of the FIR, but then he fairly submits that she was present when the incident took place.
Yes.
And that she apprehends the arrest. She apprehends that there is likelihood that she may be arrested in connection with the said case. Okay, so you insert it somewhere. And then in the conditions, number 2, she will make herself available for interrogation by the investigating officer as and when called for. The same conditions, the applicant shall not directly, indirectly make inducement and all that. You will not leave the place without permission.
Yes.
Okay.
Obliged,
This
ma'am.
will be entered. List it on
22/7,
22/7,
2025.
2025.
My lord, a small player.
Scan copy of the case diary
Yes.
along with the medical reports also.
Okay. Scan copy of the case diary.
Along with the MLC reports also.
The scan copy of the case diary is called for from the. It's okay. Scan copy of the case diary in connection with so and so case is called.
My lord,
this
small player, my lord.
plus medical MLC report also. yes.
Along with the medical report. Scan copy of the case diary along with the medical report may call for in connection with so and so.
My lord,
Ah.
I'd like to mention that 5 days of the receipt of the CTC of this order, man, because Saturday, Sunday is also there. Can it be done?
5 days from receipt of the instant order.
Highly obliged, ma'am.
From the date of the receipt of the instant order.
Highly obliged.
AB
My lord,
in respect of 12.
12%, my lord. And my lord, item number 5 also, my lord, connected matter. There I am seeking for quashing of the FIR, my lord. My lord. This, my lord, this applicants, my lord, 12 in numbers, my lord. They, pursuant to the advertisement issued by the, my lord, staff selection committee, my lord. Pursuant to the advertisement issued by the staff selection committee is for the central government job, my lord. That for the recruitment of multitasking non-technical staffs and Havaldar, they participated. And they got qualified even. And result was declared. So what happened? There is a, my lord, as per this guy, there is a one stage that for document verification. So they were asked to come with the documents. They went with the documents. during verification, the staff selection committee, they're saying that your permanent address and correspondent address, it doesn't match with your document. So this thing, madam. So examination, it was held in 2023, my lord. Result was also declared in 2023. And when then we were debarred from the disqualified, and even we have been debarred for 3 years from sitting in any examination. So this much of harsh punishment given to us. Then we have put to challenge this order before the CAT Administrative Tribunal. Administrative Tribunal, after relying on the Supreme Court judgment, these are the clerical mistakes, has stayed the debarment. Then in the meantime, my lord, that affidavit of opposition was filed by the Staff Selection Committee. There we have come to know that FIR has been annexed. The present FIR, that's in the 2025. Now, in the FIR, I will take my lord to the FIR. Now, in the FIR, there is no specific any allegation of committing any offense. It's only saying that we have a suspicion how these people could score so much of mark. We saw them of frequently visiting this washroom also. That's why we have a very high suspicion that they must have done some malpractice. Therefore, in that way. So my understanding.
So FIR is on a total different issue.
Total different, but now they are just trying to justify their debarment order. They have annexed in their affidavit of opposition before the case, saying that these people had involved in such activities. So they're trying to justify. So what I'm saying is that 2023, man, they could have lost the FIR against us. 2025, after when we put to challenge, when the stay order was granted, what made them to all of a sudden come and filing the FIR? My lord, then I will directly take to the FIR, my lord.
Only to defend the bar.
Defend the bar, my lord. And my lord, I'll just
afterthought, according to
afterthought. And my lord, I will show the FIR, my lord, that contains, my lord. This is rather a fit case for quashing, my lord. That Bhajan, even uncontroverted allegation taken on its failure, my lord, it will not make out the case, my lord.
Where's
Back to
the
the FIR, my lord, I will take directly to the FIR. Page number 39, my lord. My lord has got. Page dated 16 January 2025, my lord. Now, I'll just read my lord. Complaint against 13 candidates involved.
It's a very long FIR, it seems.
A long FIR, my lord. Reading, my lord, not that long also, my lord.
Yes.
And my lord will find out, my lord, whether any criminal elements is there or my lord. Not my lord.
This is registered under what? Cheating meeting?
My lord, this is...
Cheating.
No, my lord. This is first registered 418, my lord, which is a bailable offense. 418, my lord. 468, this is only the non-bailable, my lord, which is 7 years up to, my lord. 471, my lord, this is also bailable, my lord. Then now only 468, that is non-bailable.
Forgery.
Forgery. Now, my lord, reading all this contents of the FIR, my lord, how these sections are attracted, I just don't understand also, because we have scored good mark, we are qualified, and they have some suspicion how they could do. This is only the allegation.
Okay. Let me see the contents.
Yes, madam. I'll just read it out. I'll just read it out.
You are praying for an interim here.
My lord, my lord. I'm praying.
Let the case diary be. Did the case diary come? We can examine in details.
My lord, my lord. Then in the meantime, I may be protected. Yes.
I have an objection with interim.
Okay. Let me see the FIR first.
FIR, my lord.
If it makes out a cognizable case, even if those ingredients of the sections are not there, will not matter.
Absolutely.
So let me see if cognizable offense.
39, my lord, page number. FIR was filed on 16 January 2025. Complaint against 30 candidates involves conspiracy and malpractice during so and so. It is to inform that
Examination of 23.
My lord. It is to inform that the multitasking non-technical staff Havaldar was conducted on between so and so September 2023 in the 3 seats in the design exhibition so and so model based Naharlagan in the district of Papampara. During the examination, certain irregularities and malpractice were observed, and it is suspected, my lord, that 13 candidates who had appeared for the exam were involved in the same. Now, what is suspected? What are the examination details? The staff selection committee by notification dated invited application for recruitment so and so, and result thereof was declared on 18/12/2023. My lord, kindly note, result was declared on 18/12/2023. They conducted examination in the month of September, my lord. In between this time, my lord, if because everything was with them, my lord, CCTV was, result was even declared. What prevented them from lodging FIR?
Maybe some inquiry?
No, nothing.
No.
Then after, only when we approached the gate only, my lord, that's right. Now
Let's
everything.
go through.
Yes. The staff selection committee by so and so, during examination, the commission observed that a total 13 candidates who appear in the MTS examination from the venue in
Where are you reading?
My lord,
After 1812. Yes.
details of the incident, my lord. Yes, my lord.
During scrutiny.
My lord,
After 1812.
after it, yes, after 18. During the scrutiny, the commission observed that a total of 13 selected candidates who appeared in the MTS examination 2023 from the venue in Naharlagan, Itanagar, have secured very high ranks, and 8 candidates are within the top 60 merit position. The total numbers of candidates who appeared from the said venue were 601. Accordingly, the CCTV footage and candidate CBA answer log details of 13 candidates pertaining to MTS has been examined, which prima facie raises some suspicion regarding the irregularities and malpractice of this so and so and so. Now, my lord, what are the suspicions?
So scrutiny was done during scrutiny.
My lord.
Scrutiny means before declaration of the results.
Yes, my lord. During the scrutiny, my lord, the total who appeared in the examination from the NAL have secured very high marks are within so and so. This scrutiny, definitely this, my lord, after, before declaration of the result, this scrutiny was done, my lord.
Okay.
Then thereafter, my lord, suspicious activity, my lord. Next. During the examination, it was observed that 13 candidates appeared at the examination center were frequently visiting the toilet area and exhibited suspicious behavior. This candidate visited the washroom multiple times during the exam period and taking unusually long time. And it appears that they had answered question without using rough sheets. It has been further reported that analysis of candidates so answered log details revealed that these 13 candidates have answered 30 to 50 questions within 2 and 3 minutes, which is highly implausible under normal examination conditions. This rapid answering pattern is inconsistent with time and cognitive effort required for answering exam question, especially when no other candidate displayed similar speed in answering, which is concerned about the possibility
How did they come to know that they have secured 30-50 questions within they have answered within 2-3 minutes?
There's CCTV, Your Lordship.
CCTV, but it's not written here.
Yeah.
The soft copy
No,
is
now
given in the.
what they are saying that they have analyzed the log details, my lord. It's what they are saying, my lord. Now the allegation is about the possibility of unfair practice and conspiracy on their part.
Wait, this rapid answering pattern is inconsistent with the time and cognitive effort requiring for answering, especially when no candidates display similar speed. Okay, possibility of unfair
practice and conspiracy on their part.
Okay,
Now, mother, document verification. Upon suspicion activities being observed of the 13 candidates, it was found that out of the 13 candidates, correspondence and permanent address of 11 candidates are in A sector or G sector or S sector in Naharlagan district, Arunachal Pradesh. Pin code of 11 candidates is so and so. Further, all these candidates had mentioned their address of Haryana in the commission copies filed by them during the examination. After that, when the candidates were called for physical verification document on 15/5/2024, out of 11 candidates, only 10 candidates attended document verification and 1 candidate was absent without any justification. And out of 11 candidates...
The documentation was after the results, right?
Result, my lord, it was on 15/5/2024, my lord. 15/5, my lord. On that time also they could have filed even on 15/5 or after some that. Then again waited for like until their order was put to challenge before the CAT, my lord. Now,
Okay, after that, when the candidates were called for physical document, yes, verification on so and so.
they have failed to provide any
Attend-
document in support of their permanent address mentioned by them at the time of filing of the MTS application form, which raises concern about the possibility of unfair practice and concern. But here also, while no specific allegation, is saying possibility of unfair only.
Just a minute, I'll just read it
Well-
again. And out of the 11 candidates, 10 candidates will not be given. Moreover, at the time of filing of the document verification, some of the candidates has filled a new address, which is neither matching with the correspondence and permanent address filed at the time of so and so. They were actually from Haryana, it seems.
What happened, madam?
So-
Correspondent address they gave to Naharlek.
Hmm.
Since they were here with some of their relatives, they wanted to give exam here. So what happened in the application form? Now what happened in place of correspondent address,
Hmm.
it is shown as a permanent address.
That is the mistake.
Yes, and in place of permanent address, it is shown as a correspondent.
Hmm.
For that, we have been debarred. We have been disqualified.
Hmm.
But the CAT says that such, as on now, prima facie, relying on the apex court's judgment, the CAT is of the opinion that the prima facie case has been made out. For this clerical error, they should not be disqualified. That's why that has been put on hold as on today, madam. Now thereafter, madam.
Clear violation of para 20.1 of the commission standing instructions.
Yes, ma'am. For that one, my lord, they have a power. But ipso facto, that cannot be said in a criminal action, criminal case, my lord. For that one, they have debarred us from the disqualified us from the examination. Madam. Further,
That is too harsh a punishment for this address thing.
yes, this is a very harsh punishment, and not only disqualified in this examination for 3 years. And my lord, we are not something of very for a high job. It's class 10 pass matriculation job. It's a Havaldar and MTS. So we are not something. It's for a very group C post, my lord. So we are from very poor family background, or it's not something, my lord, very highly qualified person also, my lord. We are of matriculation only, my lord. Now,
Okay,
my
fine,
lord.
Go ahead.
Further, as per the notice of the examination, dates of window for application form correction and online penalty was provided to all the candidates between, meaning thereby sufficient opportunity was given to all the candidates to correct the application form. In spite of this, the above mentioned candidates have not corrected their address, which shows that all the above candidates are hand in glove while engaging in suspicious behavior and malpractice while undergoing the exam by choosing the same center of examination or Arunachal Pradesh and committing the same mistake, which no ordinary prudent man or woman would hand. So these facts and patterns strongly suggest that the possibility of well-organized conspiracy involving the candidates. Here also possibility saying, considering the above facts and also with undergoing CCTV footage from the exit, candidates answer log details, applicant forms candidate response patterns showing an unnatural high speed of answering questions and document verification of the candidate discrepancy in the prima facie show that the above candidates malpractice by engaging hand in glove along with external collaborators related to the examination center. It is hereby requested that thorough investigation be conducted into the activities of these 13 candidates to determine the nature of their involvement in the conspiracy. And there is a high probability there is
It's
involved.
okay.
Now, this is the allegation. Now, the reading of this FIR. How, my lord, this 468 has come, my lord. Now, others, my lord, this for correction event, we ourselves wrote to the commission. Later, when came to know that there was a mismatch between these things, we wrote the application representation. Kindly, this mistake, this error occurred in the application form. Kindly allow us to rectify this thing. We approached. And during documentation verification on that ground, now, my lord, question is there. Now
But
that
they did not, in spite of the opportunity given, they did not correct the applications form.
no, my lord, we approached the authority to allow us But since it was not within the window period given, my lord, then subsequently we approached before document verification, my lord. But they did not allow us. So therefore, our entire, we have been disqualified. Not only from this examination, but even for 3 years. Now the question, my lord, at this stage, we have to see only basically whether this allegation on the face of
Forgery in a way that because they have said they have been going to the washroom and within 2 minutes they could do all this. So what they intend to say is that they have changed the papers. There were some other papers and then they have changed it.
I don't know what they are saying, my lord.
I'll clarify that entire story after
That's why, my
my
lord.
senior.
My lord, as on today, my lord, the allegation is not specific. Exactly what the crime that we have done, my lord. Now, my lord, if say that visiting the toilet is a crime, then I don't mean.
It does not mean that it is a
Yes,
crime.
exactly, my
What
lord.
they mean is they have changed the papers. Something
Yes.
went.
So they could have come with specific those things and how it is possible. Thereafter, my lord, now saying that scoring good, not using the rough sheet. There is only mathematics paper, reasoning 1 or 2 paper. Others are, my lord, English paper and GK knowledge. For that, how I will use the rough paper, my lord, rough sheet. I don't need to use the rough. And for even logging, my lord, before answering, if I see all the things, thereafter, if I start logging, even that is possible, my lord. So what is so abnormality? Even if it is there.
Yes,
So,
one thing is there, it's all suspicious.
yes,
Suspicious.
so now, my lord, this is the case. Now, my case, my lord, as of today, my lord, this section registered. What's the forgery as well? Which document I have forged, my lord? Only section non-available is forgery. Now, cheating, my lord, how the cheating arises here? How I have made misrepresentation to anybody, I have induced anybody to deliver me property or I have gained any benefit. I have been rather debarred from 3 years from even participating in any examination. Man. Now,
What is 471?
471, it's a forgery for cheating. It's a bailable offense. Using document is genuine, I think. This is 471.
Okay, this is only first stage, so what I'll hear more.
Your Lordship, I'll just clarify to that. Your Lordship, if Your Lordship sees the FIR, Your Lordship will find that this was advertisement was issued by the central government, Your Lordship. And the place of examination was divided into zonal group, Your Lordship. Will see if Your Lordship will then come to page number 31 or 39. If Your Lordship just see the first paragraph, it is so and so multitasking staff and Havaldar exam 2020 conducted on so and so September in 3 shifts in designated examination center, that is ION Digital Zone IDZ Model Village Naharlagan. So 1, 4, 5, 6, 8, 11, 12, 13 and 14 September examination was conducted in the state Naharlagan, Your Lordship. Now Your Lordship will say that this is not, if we see it through the FIR, Your Lordship is well aware it's not an encyclopedia. There were other FIRs in other states where the examination was held, Your Lordship, which also includes the state of Mizoram, Your Lordship. Your Lordship will see after the receipt of FIR, Your Lordship, where the investigation has led to was that there is a Haryana-based coaching center, Your Lordship, where after a person applies for these examinations, they get an admit card, Your Lordship. Once the admit card is being given, Your Lordship, they are trained to train with devices, Your Lordship. One of the device include the GSM enabled device, which is with the other person who is not appearing in the exam, and a small earpiece, which is with the person who is sitting during the examination.
Being trained.
Yes, Your Lordship. That 1 month of period they are trained in Haryana, that center, Your Lordship, along with the gadget, Your Lordship. Once they sit in the examination hall, Your Lordship, those gadgets are inserted in their ear, and that's when the reason the apprehension made, Your Lordship. They will just question, they'll just ask the questions, and the person who is sitting on with the gadget,
They won't be allowed in the examination.
exactly, that was not done. No, it could not have been detected, Your Lordship. Those devices were of such nature that it could not be because it was inserted inside the ear, Your Lordship. The device is so small that it was inserted. It could not have been identified during the checking of this, Your Lordship. Now it has opened a Pandora box, Your Lordship, where these Haryana-based coaching centers are also being investigated, Your Lordship, and the states where these examinations were held are also in the realms of the investigation, Your Lordship. Now, if Your Lordship will see, this is not a simple case of where the examination, since the examination was already held in 2023, Your Lordship, since there was a modus operandi, Your Lordship, which continued to the later stage of the years, Your Lordship, when these examinations were conducted, Your Lordship. That's when these FIRs, be it of a belated state, were given, Your Lordship.
But
it
why
was
so late?
No, because subsequently they came to know with certain incident that this is happening. When the investigation happened, this this examination center in Haryana, where the training was happening, Your Lordship.
Been stated in the FIR, not stated.
Yes, Your Lordship. Therefore, Your Lordship will see that there is no specific and only on suspicion, Your Lordship.
You are right in saying it's not an encyclopedia, but the basic facts, why it is so late.
Yes, Your Lordship.
No reasons actually, why it has been so late.
Even the FIR, I admit to the fact that even the FIR states that there is only a presumption this FIR was given, Your Lordship. Why? Because certain things has happened subsequently, Your Lordship. There was an investigation, and through that investigation, that Haryana-based center was revealed, Your Lordship, and subsequently only on suspicion this FIR was given, Your Lordship. After this FIR was given, Your Lordship, the police investigated and it came to the main route of center point of where the initial of preparation of the crime was happening, Your Lordship. That's how the investigation has come to the center point, Your Lordship. There is not only the case, Your Lordship, there is also a case in the Mizoram, Your Lordship, where another center was where the examination was held. At this stage, at least, Your Lordship, if Your Lordship, because interim, Your Lordship, at least.
Mr. Sonar, right? Rajesh Sonar, yes.
Well.
Sonar, what transpired from her submissions is that it's a big racket, it's a big issue, which is has to be investigated, because this is not something small.
Well,
If there are coaching institute of these kinds, and those small chits, gadgets are used, and then it will lead to a disastrous consequences.
And Your Lordship will also
let me see the case diary and pass on this. As far as interim, I don't think so.
My Lord, this is the case, my Lord. My Lord will see that the offense, my Lord, criminal. At the most, my Lord, forcing, no sections, what the sections there, my Lord? In my case, my Lord, where is the allegation of criminal?
No, you are right. You are right in
my
saying.
Lord, now only because in some investigation, in some case, this was found. Now, can my Lord, any case, whenever examination can take any FIR file, any doubt is created, can we say, my Lord, this all are the same? Let them come with the definite, my Lord, evidence, anything, my Lord. But only because, my Lord, this sweeping statement, because FIR doesn't disclose any, my Lord, forget about the.
FIR does not disclose.
My Lord, forget about the, my Lord, arrest, my Lord. This is a fit case, this FIR, how it will stand, my Lord? Case has to stand by the FIR.
No, you are right in saying that those things are not here.
My Lord.
But then she said it is all on suspicion, that till that time they were not very sure.
Let them do the investigation, my Lord. I am not preventing them, my Lord. They have a right, my Lord. Now, let them do the investigation. Let them come with the investigation, my Lord. But I have to be also, my Lord, protected, my Lord. My Lord, how my Lord, right now, how it can be, my Lord, without there being even any allegation, my Lord, to say that I am involved in such kind of way. Yes, and my Lord can see the nature, my Lord. My Lord, this, my Lord, kindly, in our case, my Lord, this signal jammers was installed, my Lord, examination center. And in our case, is a bit different, my Lord. Why, my Lord? This FIR, this is not the fact like they did not know about these things. This FIR, when it was filed, this FIR, my Lord, will kindly turn to, my Lord, this, the order passed by the, my Lord, this CAT, my Lord.
It's okay. Hey, there are no reasons given now why it is delayed.
No, my Lord. No, my Lord. My Lord, all of a sudden, then what is the purpose in the justification to justify their order, my Lord? They enclose only after, if had we not put into challenge their debarment order, my Lord, then definitely, my Lord, nothing would have come, my Lord.
But one thing there is, Ginny, because you know, Supreme Court has said, if there is any delay, There has to be some reason.
Yes, Your Lordship.
So in the FIR, they did not write any reason.
Absolutely, Your Lordship.
Because the offences were committed long back.
Long back, Your Lordship.
2023.
Yes, Your
But
Lordship.
now there is no reason in the FIR.
Yes, Your Lordship.
Plus it is only on suspicion. Okay.
Yes.
After that, investigation went on and
Yes,
it's
yes.
found out.
Yes.
And it's a big issue.
Yes,
That
sir.
is
They
without doubt.
different issue altogether. Madam.
But what I'll do is you bring the case diary.
Your Lordship can give a short bit because why I'm not totally against this accused that Your Lordship will see that all of these candidates were from Haryana, none from the state, Your Lordship. Only only through the state, because this was a advertisement for the all over the India, Your Lordship, not only for a particular state, Your Lordship. Now, even in this case, Your Lordship, only through the CD we can ascertain since because this FIR was of January 2025, Your Lordship. Now it's June, Your Lordship. Till this 6 months, Your Lordship. What was the outcome? Why was this FIR of 2023 action taken in the year 2023 was given in 2025? Can also be ascertained from the CD, Your Lordship.
Yeah, that can be ascertained, but it is the duty of the police.
Absolutely.
Right.
Yes, yes.
So what I am on is I'll give interim, you bring the
Your Lordship may kindly, Your Lordship will have difficulties. Your Lordship is because I'm only on instruction, Your Lordship. Your Lordship will see, though there was a submission not bringing into the entire facts, Your Lordship. My only instruction was with regard to how this investigation, how these activities of the accused came into light, Your Lordship. Now, if any interim is given, Your Lordship, it will in every manner hamper because they, as I have already stated, Your Lordship, they were together they were trained after getting in the admit card.
Had these facts been brought on?
No, Your Lordship, that could not have been brought into the FIR. Why? Because as I have already stated, Your Lordship, the FIR, since on the subsequent later stage, in another case, when the investigation came into light, Your Lordship, that's when this happened. And only through this, the sequence of events that has been happening through the centers, Your Lordship, this FIR was filed only on suspicion. Because if we would have named all the entire participant, Your Lordship, it would be wrong on the part of the informant, Your Lordship. Your Lordship will also see that the FIR was filed by the Selection Staff Commission, Government of India, Your Lordship. This is not just a simple FIR. The FIR was after certain facts came into light, Your Lordship. No, this FIR was filed only on presumption. Why? Because all the candidate could not have been blamed or made any allegation. This was only for the purpose of investigation, Your Lordship. Investigation, therefore, as per my instruction, revealed certain facts that even in the exam held in the state of Arunachal was through the process of the gadgets and the training held in the Haryana. Your Lordship,
My Lord, I am very afraid by the submission made by the learned PP. Now he is proposing, forget about FIR. Whatever, even it doesn't disclose any cognizable offense, forget FIR. We will do the investigation, we will bring the record, on that basis we will go. Is it, my Lord, not contrary to the settled
Achha, where is
position of
the order where you were barred for 3 years and all? Have you?
My Lord, I have an explanation.
it's at page number 276, Your Lordship.
276.
Second last page of the petition, Your Lordship.
$276.
Yes, Your Lordship.
265, my Lord.
260.
265.
That is the tribunal's order.
No, my Lord, 265 debarment.
Debarring. I want to see the debarring.
Yes, my Lord.
Achha.
265, my Lord. This is regarding debarment of Ajay, my Lord. My Lord has got para 5, my Lord. Serial number 5.
The candidature of Ajay. Ajay is what? The
Petition number 1, my Lord, applicant is cancelled and he is debarred from appearing in any future examination conducted by for a period of 3 years.
So there are different orders for each and every one.
Yes, my Lord. I have enclosed here, my Lord.
Even to this,
From appearing in so and so. What is the reason?
Reason given, my Lord, only this correspondence address.
Address only.
Only, my Lord.
Your Lordship, that part of.
I am very afraid, my Lord. Then what is how we will get ever, my Lord, quashing of the FIR if we go by this proposition?
No, I'll just
My Lord,
place
knows the settled proposition of law. Bhajan Lal clear. We will not go what the investigation subsequently comes, my Lord. We cannot, my lord. On the face of it, if the FIR doesn't disclose the cognizable offense, FIR, can the police can say, my lord, we have conducted investigation, we have brought, FIR can be modified, my lord. Now here is the case, my lord.
This is an AB, they are here.
Yes, your lord. I'll
I'll give the conditions that they will appear within 5 days and give their
Your
statement.
lordship, there is I'll just come to that, your lordship, that the tribunal, your lordship. Why? Because we are separating the entire case differently, your lordship. 43 at page number 43 is the notice where the examination notice was published, your lord. 43, your lordship will see.
43.
Yes, your lordship.
Yeah.
43, your lordship will see. This multitasking non-staff and Havaldar examination of 2023. Now, subsequently, your lordship will then come to page number 73, your lordship.
73.
The FIR also referred to 25, your lordship. Action against candidate found guilty of misconduct, your lordship. 5 says making statement which are incorrect or false, suppression material information, submitting fabricated documents. Now, with regard to his debarment, is only on the sole basis of this notice, your lordship, because the notice of the examination clearly brings into the section which states that if there is any misconduct by the candidate, if he found guilty of the misconduct, he will be debarred from the examination. 25 states so. Now, in this debarment order was given only in terms of this case, your lordship. Totally a different case to the FIR file, your lordship. Though the candidate may be same and the same examination was held, but the totally different, since he has violated section 25 of the notice, your lordship, he was debarred and therefore he approached the CAT, your lordship. That's a totally different case. In case of FIR, your lordship, there was an issue with terms of manipulation of the answer sheet or the answer and the way that the examiners answer their sheets, your lordship. And investigation therefore reveal, your lordship.
Now, why I'm on with the interim is because of few reasons. One, there are no reasons in the FIR. If we have to go by whatever.
None of the accused has been given, even on the earlier occasion, they has approached this court, your lordship. None of the accused were given bail, your lordship. All the accused are, if your lordship, if
Those cases are, my lord, specific allegation is there, my lord. Now, my lord, may I submit, my lord?
Only 13 candidates.
My lord.
And he is appearing for 12. What happened to one?
One, my lord, he did not even appear for the verification. My lord. That's why I think he is not maybe.
Your lordship,
not happy.
your
My
lordship.
lord, may I submit now? Now, first question we have to understand. What is the cognizable specific offense? Let's assume that whatever he is saying, even right. Let's assume for it. Let's go by argument. I will not dispute her facts even. Let's say that the FIR is in that way.
See,
Now, my
it's
lord,
written prima facie raises some suspicion.
my lord. Now,
So it is
another
on
question comes, my
suspicion
lord.
stage.
Suppose 468 comes, 7 years below, my lord. But what the law says, my lord, section 41 of the thing.
41.
Only prima facie is not satisfaction. My lord, there has to be a necessity of arrest also. Now, my lord, this offense alleged to
468 entails how much of punishment?
below 7, up to 7 years. My lord, now another question. This offense allegedly took place in 2020. What is the, now is it my taking me in the custody? How it is going to serve the investigation, my lord? Let's assume, my lord, even some,
Thank you.
my lord, those things have to be taken.
Bail matters have taken so long.
Yes,
my-
I'll just rely
Yes.
page
Lord,
number 18.
until
because some-
this judgment, my lord, will see this repeatedly, my lord. Our this saying Apex Code is saying, my lord, this liberty is one of the most essential requirement of modern men, my lord. It is, my lord, 2022-10 SCC Satyendra Kumar until judgment, my lord.
It's
Well, it has said, my lord, below 7 years,
Facts are totally
up to 7 years. Why you need this? Only prima facie commission is not enough. Now, what's the necessity? In my case, my lord,
I'll just rely
neither prima facie is there, neither the necessity is there. No, look, what is the necessity of arresting me? The offense allegedly took place 2023. Even if something happened, I used there. How it will make any difference taking me into the custody, my lord? Even if I go by her allegation. My lord, it is not something, my lord, just because somebody makes arrest, my lord, still presumption of innocence is in my favor, my lord. Now, It is not only, my lord, because some allegation now, that too allegation is not there in the FIR. Learned PP has brought from her own, maybe her
Not
own,
on.
the
No.
on means like as per the record
Instruction,
instruction, right? So on that basis, saying, my lord, now, my lord, law is very saying clear, my lord, that it is not only for the offense below 7 years, my lord. Otherwise, even let's assume my case is above 7 years. Again, my lord will see that is it something only allegation one has to be there before punishment, my lord.
Okay.
I'll just paragraph 18, Your Lordship, because there is a contention that prima facie and so cognizable offences dispute, Lord. If I may read, Your Lordship, it is a trite law that FIR is not an encyclopedia of all imputations. Therefore, to test whether an FIR discloses the commission of a cognizable offence, what is to be looked at is not any omission in the accusation, but the gravamen of the accusation contained therein to find out whether prima facie some cognizable offence has been committed or not. At this stage, the court is not required to ascertain as to which specific offence has been committed. It is only after the investigation, at the time of framing charges, when the material collected during the investigations are before the court has to draw an opinion as to for the commission of which offence the accused should be tried. Prior to that, if satisfied, the court may even discharge the accused. Your Lordship will see, we are in the phase of investigation. Now, if I may also bring to your Lord's notice, that debarment was in the year 2024, the order of debarment. Even till that time, these facts that such thing is happening, Your Lordship, was never before the commission, Your Lordship. Therefore, there was no FIR. It was of the year 2024. Subsequently, these issues came into the notice of the selection board when this FIR was given, Your Lordship. Now, Your Lordship will see that I have already submitted this investigation and the FIR in other places has opened a Pandora box, Your Lordship. Now, out of all the candidates, 13 of them are before this court, Your Lordship. One of them is not there because he did not turn up during the documentation. Now, 13 of them, Your Lordship, if they are left free, Your Lordship, the person who has trained them, the devices, Your Lordship, the coaching center as has been in my summation, Your Lordship, all that has been, this will be influenced because they are neither the state of investigation is done by the state police of Arunachal Pradesh, Your Lordship. They'll be going back to Haryana, Your Lordship. As I have already submitted, Your Lordship, every detail of how the examination has to be prepared, Your Lordship, all this thing has taken place in Haryana, Your Lordship. The base of the entire thing is in Haryana, Your Lordship. There is high chance that all these people would in any way tamper with evidence, Your Lordship. All 13 of them are before this court, Your Lordship.
When can you bring the case diary?
Next Monday, on Monday, Your Lordship. A short date because this is of Itanagar only, Your Lordship. I have at least 2 days of time, Your Lordship. If Your Lordship just grant me 2 days of.
Let the matter come up on Monday.
Lord,
I'll see the case diary and I'll pass.
My lord, kindly, my lord, may I just refer this?
Do you understand?
My lord, this judgment, my lord, until what is saying, my lord. My lord, otherwise, my lord, this is the case my lord has seen. Where this will be a quite injustice to the applicant, my lord, when there is not even a prima facie.
No, I have to balance both the sides, right? Then her instruction is
My lord,
that
then,
it's a
my lord,
big
my lord.
racket of this kind of.
But we cannot go by the. My lord,
Imagine,
kindly, my lord, we cannot go by the allegation. Even say the record.
Now,
But
at this stage, we have to go by allegation.
My lord,
only,
that's
just
why, my
to
lord,
prove.
allegation on the record, my lord, FIR. What is there? What is, nothing is there against me in the
Then
FIR.
let me see the case diary and I'll pass orders. And there is
And
enough
my lord
time
has
that
seen,
I've given you.
my lord has seen this until judgment also saying this.
Until judgment, I know.
That is saying, my lord, that this particular case, my lord, this saying that liberty is one of the most essential requirement of the modern man. It is to be delicate fluid of mature civilization.
Yes, Article 21 is there. Who
Then, my
denies?
lord, is saying that so far offense up to 7 years. The court is saying, my lord, and my case is, my lord, has seen. This is a case, my lord. Otherwise, my lord, how to approach when there is not even a prima facie case in the FIR also? Then what argument I should place, man?
Yes.
I don't know even what is the section against, what is the section? Well, then let her to tell what criminal offense sees.
Let's see the CD in that case.
My lord, without, there is.
Only 2 days, Mr.
I understand.
So Monday you come and we will pass.
Monday, well, I have even put to challenge this FIR.
2 days, nothing will happen. Don't worry. So Monday I'll pass the necessary order.
Well, Monday I have some difficulty, my lord.
This heard Mr. R. Sonar appearing for the applicants as well as T. Genie. By this application, the the petitioner, by this application filed under section 482. This is 482 application. Yes.
Item number 5 is 482, my lord.
Oh, 482, yes.
My lord, this is a
482 of PNSS 2023, praying for grant of PRS bail in connection with Naharlagun Police Station case number 11 of 2025, registered under section 480, 468, 471, 120B and 34 of the IPC, arising out of the FIR dated 16/1/2025. I'll not write anything. Call for the case.
protection, my lord. This is if I don't get interim in this such case, my lord. Then in which case I will get, my lord? I don't understand. I will not have any better case than this to argue, my lord. And I think whenever we get some prima facie case, I always find in the FIR. And this is the case, I don't have even that prima facie. And I don't know what section I am culpable. I don't know what charges against me. And
no,
some protection at least, my lord. I have, and my lord, at the top of it, I have put to challenge even the quashing of the FIR.
No,
this is a fit case. My lord, maybe my culpability, all those things, maybe another issue, but I have to go by the record, what is there on the record, my lord.
Yes.
Because submission cannot be the thing to deprive my liberty, my lord. She may make lots of instructions, she may make lots of submission, my lord. But my lord, kindly see the FIR itself, my lord.
No, I have seen the FIR.
Then
and
if I am not here,
and
my
I'm
lord,
not giving you a long date. It's only on Monday that I will see the CD and pass orders. Bear with me for 2-3 days.
my lord, then my lord, Tuesday.
Because yes, you have a right for your personal liberty. Article 21 is there writ large. But then incompetent people getting into the jobs and by those illegal methods should also be, I'll have to balance it.
Well, I understand. But my lord, only allegation, because everything has to be due process of law.
Everything has to.
Process of law, my lord. The deprivation has to be due process of law.
Not due
Now,
process.
due
We
process
have-
means what?
There are anomalies.
That's disclosure of some cognizant offense has to be there. That is the due process of law.
Therefore,
Now,
it's
my lord,
always
because of apprehension, somebody is involved here, somebody is doing, and I don't know even what is the section will be applicable against me, my lord.
I'll have to check on.
My lord, as my lord wish, my lord, this matter may be on Tuesday. No issue, no issue.
Yes.
My lord, as
Not write
my
anything
lord,
now. Call for the case diary. Fix the matter on Tuesday.
Deep paper.
this item number 5 also, my lord, together.
Same.
On that day, my lord.
There also case diary will be there. So
Lordship, item number 5 is for quashing. Notice may be issued in this matter, Your Lordship.
item number 5.
Same FIR, but then it's a criminal petition for quashing, Your Lordship.
There, I think only you are eligible.
Yes,
Your
my
Lordship. As a formal notice needs to be.
Item 5, heard Mr. R. Sonar and Ms. T. Ginny. This is an application for quashing of the FIR dated, quashing of the FIR, right?
Yes, Your Lordship.
It is an application under Section 528 of the BMSS 2023, invoking the inherent power of this honorable court, for quashing the FIR dated 16/1/2025, registered as Naharlagun Police Station case number 11 of 2025, under same sections, 18, 68, 70 of the IPC. Call for the issue notice to respond number 1. This number 1. There is only one respondent, right?
Yes, Your Lordship.
No, not issue notice. Miss Jeannie appears for respondent number 1. As she has appeared before this court today, no formal notice, but extra copies to be given by by the petitioner to her within the course of the day. Let the matter be listed on Tuesday. Otherwise, technically, you're entitled for a bail, but then let me see what it is.
My lord,
On Tuesday, I will consider.
Deeply approved.
deeply approved.
Lordship, this is a anticipatory bail, Lordship, under section 482, Lordship. Lordship, FIR is of 2022, Lordship.
Arms Act is there, 326-307.
Lordship.
Only.
Lordship, there is an inordinate delay in the investigation, Lordship, not on the part of the investigating agent. Lordship, of course,
Murder with arms.
nothing as such happened, Lordship. Nothing as such happened on that day, Lordship. I have rather this is a case of a counter case, Lordship.
Anyway.
I have filed. I was the one who has filed the FIR first, Lordship. I have annexed that FIR also, Lordship. Lordship, the dispute is arising out of a lane, Lordship. Both the parties were on the spot, Lordship, and there was a scuffle. And FIR and a counter FIR was filed, Lordship. Now, there was no investigation going on it for the last 3 years, and suddenly the
You have annexed both the affairs here.
Lordship, I have annexed both the affairs.
Let me go through where you are the accused. Which was at earlier point of time.
FIR against me is at page 19, Lordship. Written FIR, Lordship.
Mr. What? Who? Dikimso. Pakhong Dikimso. The
Lordship.
petitioner's name? Yes. Let's go through.
I, Sri Sukra Sen Chakma, age about 39 years, son of so-and-so, village under Mio Circle, Tanglang district and Longding, lodging this first information seeking appropriate actions from your end against the accused perpetrator, Lambusul, injured Miss Man. I stated the facts as under that on 20/12/2022, I requested 3 of my friends, namely Sri Udonga Muni Chakma, son of so-and-so, 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 Satyavan Chakma, so-and-so, so-and-so.
Sen Chakma.
Yes.
You are not here.
Lordship, these are the name of the informant, Lordship, in fact.
Oh, I requested 3 of
Yes,
fine.
I
Read it out.
requested Iblis to help me to dismantle my Joom house located at my Joom lane in Nandan Kanan village and to carry out the reusable construction materials back to my main residence in the village. That pursuant to my request, all 3 friends reported to my residence early morning on so-and-so, and after having breakfast, 4 of us reached my Joom house at 10:30 a.m. After taking a rest for a few minutes, we started dismantling my Joom house and completed the dismantling by around 11:30 p.m. 2 Mismi men, name not known, were present at the spot when we were dismantling the house. And I also borrowed their Kili Barito, take out the nails used in the house. After dismantling the house, all 4 of us started carrying the reusable construction materials such as woods and leaves used in the roofing. That at around 2:30 p.m., as we returned to the dismantled house to collect another load of construction materials, Lamba Solo arrived on the spot along with the 2 other Mismi men, and he looked angry. He started rebuking us for dismantling my Joom house, and when he reasoned with him, he pointed his loaded gun at the chest of Udongo Muni's Chakma to shoot at him. Lambo Solo pulled the trigger and fired the gun, but fortunately Udongo Muni Chakma was able to change direction of the barrel of the gun before the shoot and save himself from being killed instantly. Fearing for his life, Udongo Muni Chakma snatched the gun from Lambo Solo while Lambo Solo tried to snatch the dao from Udongo Muni Chakma. During this scuffle, Lambo Solo got injured on his left hand and near the neck while trying to snatch the dao from Udongo Muni Chakma.
Where is the petitioner here?
Lordship, he is this Lambo Solo. He is otherwise named as Lambo Solo.
Is the Lambo Solo Wile?
Lordship.
Lambo Solo. Lambo Sulu is the petitioner here.
Your Lordship.
I don't think so. This is a case for injury.
Lordship may
Taking
kindly.
the gun and then he had also pulled the trigger. Lambo Sulu pulled the trigger and fired the gun, but unfortunately, so-and-so was able to change the direction of the barrel and before the shot. Thereafter, all the 7 of us, what happened?
Said
discussed.
again, discussed and reconciled amicably. Odongo Muni returned the gun to Lombosolo after amicable settlement. Both parties tried to move away from the spot. Lombosolo was being escorted by 2 other missing men, but suddenly Lombosolo snatched a loaded gun from one of the other missing men and shot at
Again, after
Odongo Muni Chakma, who instantly fell on the spot. We saw that Odongo Muni Chakma was hit by bullets at his right leg below the knee, and he bled profusely. Lombosolo and his friends ran away while 3 of us somehow carried the seriously injured Odongo Muni Chakma back home. That thereafter, Odongo Muni Chakma was somehow carried up to Noagat at 10 miles from where he was
no,
taken
they
to.
will let us call for the case diary.
Lordship may kindly go through my counter FIR also, Lordship. I was the one who has lodged the FIR first. This is, in fact, the counter FIR lodged against me, Lordship. The allegations of using the gun.
Where is the counter effect?
Lordship, I was the one who has sustained severe injury, Lordship. Serious injury of a dog, Lordship.
Has serious injury by doubt.
Yes, Lordship. Page 20. They have they have admitted to that fact, Lordship. In their own FIR, Lordship. Page 24, Lordship. 21, 24.
Which is a prior point of time, both are on 21st.
Lordship, I have lodged the FIR on the same day, Lordship. After lodging of my FIR, the counter FIR, after 2 days, they have lodged, Lordship.
Yes, it is to inform you that.
It is to inform you that today around 3 p.m. when I was working with 3 others in my compound at Cotton Village, 4 Chakmas came suddenly with machete, dao and sticks, started threatening me to stop work and get away from the place without any reason. When I replied to them, then one of the Chakma attacked me on both sides of my neck and machete down many times, causing severe injury on the sides. When I tried to save myself with my right hand, and then right hand was also cut severely. The incident happened deep inside the demarcated district boundary line, and then the Chakmas came with bad intent to capture the lane.
Maybe this is a different incident. Maybe as a retaliatory attempt, he came and he was, this present incident happened. So call for the city. Yes.
Lordship, Lordship.
No, this is not a case.
Lordship, that NVW, Lordship may kindly appreciate, Lordship, may kindly come to page 26, Lordship. After a gap of, Lordship, 3 years, Lordship, the police has come up with this application before the CGM, Lordship. CGM also has negated, Lordship. There is a.
By this warrant of arrest against him?
Against me, Lordship. Praying for a issuance of non-bailable arrest against me, Lordship. Which were right away rejected by the CGM, Lordship. Observing that there was no.
Okay, let the city come, we will examine. Hertz so-and-so and Ginny. This is an application. He is not a very simple, he is a dangerous person. Let him be.
Lordship, Lordship may kindly come to page 30 also, Lordship. This is my injury, Lordship, this thing. Photographs, Lordship.
Okay, he must, what injury report?
No, photographs, Lordship.
What photographs? 30?
30, Lordship.
Oh, showing his injuries?
Yeah, Lordship.
There is no doubt. I don't disbelieve that there was no incident on 21st. There was an incident. He was attacked with a dao. Maybe he is injured. But then again on 23rd, when they went for clearing their house, he came and this thing happened.
No, sir, Lordship, the incident is of same day, Lordship. The incident is of same day, Lordship.
Same day?
Lordship.
Achha, this is on 20. This is
the incident is of 21st.
At about 3 p.m., right? The first incident.
No, first incident is on yes, same day, Lordship.
Same day, Lordship.
10 a.m. And the FIR filed by the petitioner here is on the same date at 3 p.m. As per him, the incident took place.
No, they came back at 1:30 p.m., right? In the first FIR that he read, right?
Yes.
He's an accused. So after dismantling the house, they came back at 1:30.
2:30.
2:30 they again went to collect the other load. Then this boy appeared. Then this petitioner appeared.
Yes, sir. Even both the FIR.
We're almost on the same time.
Same day, sir, Lordship, same day.
Same time also perhaps. Before the shot. So must have been 3 o'clock in both the FIRs. Four Chakma boys, those 4 Chakma boys were not named, right? By the petitioner in his FIR.
No,
No, you know.
Lordship, this is a clear case of a mutual fight between the parties, Lordship, over a disputed lane, Lordship.
It's okay, a mutual flight over but see his conduct. See, he started, initially he arrived at a spot with 2 Mishimi boys. He started rebuking for dismantling. Then when we reasoned, he pointed his loaded gun at so-and-so. And then he pulled the trigger and fired the gun. But fortunately, of course, it did not kill anyone. Then snatched the gun, somebody else snatched the gun from him. He again snatched it back. And in the midst, both parties got injured. Thereafter, see, when they reconciled, when they were going, he again attacked. He again being escorted, but suddenly Lambasolo snatched a loaded gun from one of the Mishi and shot at so-and-so. Look at his conduct. So I'm not.
Lordship, these are all allegations, Lordship.
We are with the allegations. What is the stage? I have to only look.
Lordship, they kindly appreciate, Lordship. This is a case where
the case diary
the investigation has taken 3 years' time at this stage, Lordship. The CJM also has rejected the.
Seeing the statements of other witnesses, we might also come to a conclusion that no, these are somewhat exaggerated. So let me see the case diary. So, this is a petition filed under 483 BNSS praying for grant of bail. This is a petition filed by the petitioner for in connection with Wakuru PS case number so-and-so. It's already written there. Under section 326/307 of IPC, red bit 25, within bracket 1-B, within bracket small a, /27(1) of the Arms Act 1959. Call for the case diary. Scan copy of the case diary in connection with the aforesaid case. Ms. Jenny has prayed for how much time?
Your Lordship, on 3rd, Your Lordship, because Wakro is a place, sometimes there are networks, there are no networks, Your Lordship. So on 3rd, Your Lordship.
Lordship, CD
That
will
is
take time,
Thursday.
Lordship.
Thursday.
Well, Lordship may kindly protect me, Lordship.
Third, she is bringing next week, Thursday. Next week, Thursday. Today is Friday, not even 7 days. Has prayed for a week's time to bring the CD. Beam the scan copy of the case diary. Prayer is allowed. List the matter on 3rd of July 2025. Next Thursday.
Deeply appreciate.
Right.
If you see it's a mutual fight and something, and these are all
Lordship,
young
it is
boys.
clearly visible.
These are all young boys, I'll consider, but not today. His conduct is not very good.
Deeply appreciate.
All right.
Wait, please, my lord. It is a quashing petition, my lord, under section 528 of the BNSS, my lord. My lord, it arises out of Chimpu PS case 86 of 25.
Okay.
Sections which have been leveled against us, my lord. We are 2 petitioners, my lord. It's 420 and 34 of the IPC.
Some business transaction.
My lord, basically, it should have been a civil suit, my lord, a money suit. My lord, would kindly have page 17, annexure 1, my lord. If I may kindly read the Ejahar, my lord.
The matter has reached the court.
It has reached the court. We are already granted.
Warrant.
My lord, we have already been granted bail, my lord. Both
No,
the petitioners.
No, Your Lordship, I'll just.
I'll
yes.
just. My lord, the petitioner number 2 was granted bail. My lord will have page 32.
Okay.
32 and 34 is the effective page, my lord. 34 with conditions, we were granted absolute bail. And my lord, the petitioner number 1 was granted bail yesterday by the honorable court below. If I may kindly submit this, I am submitting a
So
copy.
both the petitioners are on bail.
Yes, my lord, I am submitting a copy to my senior friend as well, because this was passed yesterday. It is not a part of the records. If I may kindly, ma'am. Fine. Yesterday I granted bail, and my lord, the NBW has been recalled as well. If my lord would kindly have that order, which I have just sent, we just handed over. My lord, shall I read the entire thing or the relevant?
The order will not have any effect on this.
My lord,
quashing petition.
NBW, one of the prayer has become infructuous. My second prayer was for quashing of the NBW
Ah.
and for staying the same. My lord would kindly have page 2 of the said order. The bottom portion, Your Honor, my lord would have, considering the submissions made and the fact that the accused applicant has already executed bail bond in compliance to his release after his surrender on 11/6/25, I deem it fit to recall the NBWA. My lord, may I kindly read the complaint once? I will satisfy the honorable court. My lord would kindly have page 17 for a moment. I'll start, my lord. With due respect and humble,
slow.
yes, yes.
Hmm.
With due respect and humble submission, I beg to inform your good office certain facts for your kind consideration. That I am the director of Messrs. Ripsita Innovations Private Limited, and the said firm is usually engaged in the construction works which required lots of machinery such as JCB, etc. As such, in the year 21, when the firm was engaged in the construction works, being necessitated to hire some JCB machinery for smooth construction, had met the above mentioned persons and came to know that they provide JCB on hired basis, who had agreed to provide his JCB on hired basis and asked me to pay some advance money. Accordingly, after finalizing the deal verbally on dated 21/7/21, I had paid an amount of rupees 4 lakhs only as an advance amount through RTGS in my PNB account so and so to Messrs. Akkam Car Accessories. My lord, this MS Akkam Car Accessories, we are the proprietors, my lord. We are 2 persons. Proprietor is Sri Baljit Singh VD and the other petitioner is also an associate. And sir, yeah, no,
How can it be?
my
It's a
lord, no,
proprietorship firm.
proprietor is my lord Baljit Singh VD and Sarabjit Singh VD. The petitioner number 1 is an associate. Perhaps the
Baljit Singh is petitioner number?
petitioner number 2.
Okay.
He is the proprietor, my lord. And Sarabjit, who is the petitioner number 1, he is an associate. But they are brothers, their own brothers, running this firm. Now, my lord had failed to provide me the JCBs as agreed and started making excuses on one pretext or others, and sometimes used to say that his JCBs are engaged in other construction works, etc. That I have made several telephonic conversations with the above mentioned persons, but on every occasion he used to make excuses. But recently, when I contacted him over the phone, surprisingly, instead of paying me back my money or providing any JCBs to me, Sri Baljit Singh VD and Sarabjit Singh VD started threatening me and intimated me of dire consequences and clearly told me that he is not going to repay the advance money, nor he is going to provide any JCBs to me, and is threatening me of consequences. That considering the facts, I have paid the money on 21/7/21, and now more than 2 years have elapsed, and he has no intention of paying me back my advance money or to provide JCB to me. Now I came to know that the whole episode has been a pre-planned long time back. He has made up his mind to dupe me. He honestly induced me to pay the huge amount in order to cheat. It is therefore, considering the above facts and circumstances, your good office may kindly register the FIR against Sri Baljit Singh VD and Sarabjit Singh VD, as their modus operandi is to cheat the people of Arunachal Pradesh who are into construction business, and if these people are not booked under appropriate sections of law, they will keep their evil intention of duping the innocent businessman, thus pray they punish for cheating and criminal intimidation. My lord, I didn't know the Adjournment was the stakeholder of entire state of Arunachal Pradesh, the kind of statements he's making, first of all. Thereafter, my lord, sections 420 and 406, my lord would have the next page, FIR. Page 20, the contents of the FIR.
See his conduct, like he has not supplied even one JCB to him. Huh? In order to see the initial inception for 420,
Yes, my lord.
it should have been from the inception.
Yes, yes.
But then here, he has not supplied anything.
My lord.
Nothing. I mean, he was only to supply the JCBs, right?
My lord,
Only JCBs on higher basis.
Yes, my lord, what has happened is that we had suffered from certain financial losses, and Mr. Baljit Singh, he had started some medical problems. Medical. He had spinal cord issues. Then, my lord, he has some tumor issues. For that, he had to take electrotherapy and others. So the entire family, my lord, they were suffering a lot. In fact, my lord, it will be wrong to suppress. So, my lord, the police had sent us summons also. In the non-bailable warrant of arrest 27/3/25, page 25, it is reflected also that police had sent us summons because we didn't appear. That is why the honorable court below was pleased to issue NBWA against us. Yes, my lord. But the problem is we were telling Mr. Ribojimo that we are going to pay you, the informant. And the police also, we told that we are in talks with them. In fact, my lord, to show our bona fides, we have paid them an advance, an amount of 50,000. Page 35, my lord would have.
Page 35.
35, Annexure 8. I have annexed the certificate also at page 36. Page, my lord, 50,000 rupees, my lord. This was on
Paid by whom?
Paid by us to the Adjournment.
Why? You are not required to pay money.
No, my lord, to return that 4 lakh, return back that 4 lakh amounts because we could not give that JCB which we had promised. My lord, the main element, my lord, in such cases, to my humble understanding, is mens rea. My lord, if mens rea is from the inception, my lord, that is not the case with us. My lord, may I kindly rely on 2 judgments, my lord? I would like to satisfy this honorable court. If I may kindly hand over the said judgments.
Yes,
just 2 judgments. I'll just try to satisfy the honorable court. My lord, would kindly have the Sarabjit Kaur judgment, my lord. 2023 5 SCC 360. Here also, my lord, this was regarding non-execution of a sale deed, my lord. The entire crux of the matter.
Everything depends on facts, actually.
Yes.
Facts always differs from case to case.
Absolutely, ma'am. I'll just try to satisfy my lord. Rest is up to my lord.
Which paragraph?
My lord would kindly have the flag portion, my lord. Page 362, in fact, it starts. 362, paragraph 11. I'll just read, my lord. Still not satisfied as the result of the earlier complaint was not to the liking of respondent number 2. He filed another complaint on 23/1/17. Thereafter, complaint was filed by respondent number 2 on 15/6/17. On the basis thereof, FIR in question was registered. On the facts of the case in hand, it is evident that efforts of respondent number 2 was made merely to put pressure on the appellant while involving her in a criminal case to get back his money. Whereas there is nothing pleaded that respondent number 2 that he was ever ready and willing to get the sale deed registered. There was no effort made by respondent number 2 or the vendee in the agreement to initiate any civil proceeding to get the sale deed executed. Exactly, my lord. They should have filed a money suit. I'm drawing parity, my lord. Now, my lord would kindly have para 13 of the same judgment. A breach of contract does not give rise to criminal prosecution for cheating unless fraudulent or dishonest intention is shown right at the beginning of the transaction. Merely on the allegation of failure to keep up promise will not be enough to initiate criminal proceedings. From the facts available on record, it is evident that the respondent number 2 had improved his case ever since the first complaint was filed. My lord, that much is relevant for me. My lord, my intentions were not evil from the beginning, since the inception.
Here there is a difference. See, the respondent number 2, he did not file any case.
Yes.
Here also you are saying he has not filed any civil case.
Yes, my lord.
But then he did not initiate any proceeding to get the sale deed executed, and it was only as a measure of pressure.
My lord, that is the parity I am drawing, my lord. Here also that pressure tactics is being played by the informant. Let me file an FIR, I'll drag him to court, he'll pay off. My lord, I was telling him, I will pay your money. Give me some time. I'm suffering from losses. My brother is suffering, Mr. Baljit. I'll pay it off. My lord, they are engaged in business since a very long time. My lord would kindly have the second judgment, Rikab Birani. My lord, this is a recent Supreme Court judgment, my lord, April 25. My lord, here also, my lord, this was regarding an oral, this arises out of oral
In
agreement.
this case, I have to see the witness's statement.
My lord,
Because it can be either this way or that way. It can be because it's already written in the FI, it's a pre-planned. Long time back, he was tried to do it. Of course, saying will not do. But then some averment is there that he had this intention from before. And then, see, and then he was paid, you were paid 4 lakhs
Yes.
as an advance payment.
Yes, ma'am.
And immediately thereafter, neither he had given you anything and he had making excuse. These are all allegations, of
Yes,
course.
yes, ma'am.
Allegations.
Yes.
So let me see some witnesses' statement. I'll call for the scanned copy of the case diary.
Till then, my lord, interim protection may be given. My
No,
lord,
Your
because-
Lordship.
my lord, just I would like to satisfy the court with Rikab Birani judgment, my lord. The stance has been made clear in these kind of cases. Perhaps Sarabjit is not that detailed. The case I had taken my lord through, but this case is very much. This also arises out of an oral agreement relating to selling of a roti godown. Now, my lord, the Honorable Apex Court has observed at page 4 of the judgment, my lord. May I read, my lord?
Yes.
We are constrained to pass this detailed speaking order as it is noticed that notwithstanding the law clearly laid down by this court on the difference between a breach of contract and criminal offense of cheating, we are continuously flooded with cases where the police register an FIR, conduct investigations, and even file charge sheets in undeserving cases.
Now, how
this is
to
an
judge what is deserving and what is undeserving? That is why I'll call and I'll see the witness's statement. Because anything will be written by anybody and you may be innocent. You wanted to go with the deal, but you could not because of certain circumstances.
Yes,
That can be a fact.
Yes.
Or it can be also a fact that you intentionally you are not paying him. So I am not here to judge. I have to see the statements of the witness. But till then,
My lord,
Your
we
Lordship,
have
I'll
tried
just
to.
pray with regard to the interim, Your Lordship. Your Lordship is I also have a citation of the exact same case when a truck was took for hired, Your Lordship, and advance was taken. But
that is what we have to see. We cannot know what exactly the situation is. We have to again put our what we have to see the witness statement. We have to see the documents. Otherwise, we have no other options. So it can be either this, either that. We cannot judge.
now,
So let me see.
only with regard to interim, because now my humble prayers, Your Lordship. Incident happened in 2021, Your Lordship. 2023, the FIR was filed, Your Lordship. They admit that they have taken the advance and they have paid on 3rd of June, Your Lordship.
2025.
Yes.
2025,
Yes,
Your Lordship.
That 50,000 rupees.
Yes. Yes.
Now I'll just come to that also, Your Lordship. They have deposit in my account, the account of the complainant on 3rd June 2025. They came with a bail application before this honorable court on 4th 6 2025, Your Lordship.
After
Not
payment.
After
20,
paying,
25, 25.
after paying, Your Lordship, one day after paying, Your Lordship. On the same day,
22,
they have
5,
filed the bail application and the matter was listed on 4th 6, Your Lordship. Now on 4th 6, interim was granted, Your Lordship. That since they had not filed for recalling, Your Lordship, the bail was not recalled and subsequently his bail was rejected, which has not been annexed in this petition, Your Lordship.
Oh no, it's not part of.
However, it's not a part.
It is a part. I'll take.
I beg to place in if
No,
that.
no, my lord would kindly have page 28 then. It is a part. I have annexed it. Page 28, and I have got interim bail. In that case,
Yes.
that case was disposed of. I was told to appear before the honorable court below, which I have. And yesterday, honorable court
It
had.
has annexed its day.
No.
there.
It's
Are they-
yes. I deeply apologize, sir. It's at page number 28. Yes. Now Your Lordship will see that investigation was pending since the FIR was on 2023, Your Lordship. Investigation was pending only because they had not appeared, Your Lordship. Non-bailable warrant was granted, issued against both the accused, Your Lordship. One of the accused was arrested in the month of May, Your Lordship. Subsequently, since he was on interim, Your Lordship, subsequently this recent bail of yesterday's order, he was granted bail, Your Lordship. Now at this stage, if the investigation is stayed, Your Lordship, there is since only because of they're not cooperating with the investigation, it was not proceeding, Your Lordship. It would every manner hamper the investigation. Your Lordship is also well aware with Niharika's case, Your Lordship. Investigation at this stage cannot be halted, Your Lordship. So at this stage only since the respondent number 2 is also part in this matter, Your Lordship, notice may be issued to respondent number 2 and also call for the scanned copy of the CD, Your Lordship.
My lord, with due respect to what my senior from the other side has just submitted, my lord, staying the matter will not stop the investigation. Police can do the investigation. They have done over the years, they are doing. We are at fault, my lord. I am not saying I have come with complete clean hands. There is, my lord. There are some lapses on our part. I am admitting to that. We are admitting to that, my lord. Now, my lord.
Well, let me see the
my lord,
witness
the
statement
case.
and
My lord, sorry, my lord, sorry. My lord, my humble prayer to before this honorable court is that even if the PS case is stayed, which is pending disposal before the honorable court below, that will not hamper the investigation. The police authorities will carry out their investigations, my lord. And my lord, this
he is praying for the proceedings
to be stayed.
Not
There is
the-
no
the
proceeding pending before the
Ah.
CJM because the investigation has not completed and it has not formulated into charge sheet, Your Lordship. There have
Yes, for bail and non-bailable warrant, you have gone to the court.
Yes, Your Lordship.
I mean, investigation is not complete. Staying visa will not have any value.
Yes.
PS case which is pending disposal before the honorable court below, the judicial magistrate first class. This court.
PS case has not returned in charge sheet. So
Yes.
these are all orders that for these different orders that you have gone to the courts. Courts have no jurisdiction in the matter. It has not. The case has not started.
Not
against
started.
you.
Trial has not
Yes.
started. Ma'am.
So no trial, nothing. It was not, charge sheet was also not placed.
Yes, ma'am.
So staying the court proceedings will have no value. There are no pending court proceedings as
No,
such.
no.
So let the case diary, I mean the scan copy come, then on the next step we will decide.
My lord, then
And finally dispose of the matter.
yes, ma'am. Humble prayer that if it pleases my lord, interim to be considered on the next returnable date.
Interim what? The entire matter can be disposed of.
Yes.
Right.
Yes, on the next day, the matter can be disposed of, Your Lordship.
FIR, this case doesn't have legs to stand, with due respect.
I heard Mr. You are
Prakitish
okay.
Sharma.
Yeah. Huh?
Prakitish Sharma.
Prakitish Sharma. Heard Mr. P. Sharma for the petitioner as well as T. Genie, the learned advocate. This petition is filed for quashing. This petition is filed by the petitioner under section 528 of BNSS case, BNSS 2023, for quashing of the Chimpu police station case number 86 of 2023, registered under section 420 and 34 of the IPC. Call for the scanned copy of the case diary. Before that, the petitioner had also challenged the order dated 27/3/2025 by which non-bailable warrant of arrest were issued against the petitioners in connection with the aforesaid case, but he had placed an order dated
25/6.
26/6.
26/6, sorry.
Order dated 26/6/2025 by which the NBW issued against him was recalled. As such, the counsel for the petitioner is no longer pressing for the said prayer. Call for the scanned copy of the case diary. List the matter after 2 weeks.
Your Lordship, there is respondent number 2 also.
Steps I have to take.
Issue notice to respondent number 2 by registered post with AD or with usual process, returnable within 2 weeks. The petitioner will take steps of service of notice upon respond number 2. Oh yes, you have already said by registered post and all, and then list it after 2 weeks. In the meantime, when can you bring it?
Your Lordship, he has proposed a date of 8th of August, Your Lordship.
7th or
Achha.
8th of
Okay,
August.
fix list the matter on 7th or 7th of August.
8th of August.
8th of August 2025. An endeavor will be made for disposal of this case on the said date, and if it could not be done so, the interim order can be considered on the next date.
I am deeply over.
Deeply.
First appearance before your lordship.
Huh?
First appearance before your lordship.
Steering you.
My lord, my lord.
This side.
My lord, today the matter is fixed for consideration of my interim prayer. On last 2 occasions, time was taken. So I am going to advance my argument on the basis of the documents and on the question of law, no facts. So I don't think instruction is required. On matter needs to be heard, my lord, so far as interim party is concerned.
Why is the urgency?
Urgency, my urgency is this, my lord. I am 2003 batch IS officer of Agmut cadre, Arunachal Pradesh, Mizoram, that cadre. I was posted here in February 2007 as Deputy Commissioner, West Kameng District. At the relevant point of time, your lordship, what has happened, for the purpose of engagement of my sister, my lord, my guests, my in-laws, they all came to my house. And engagement could not be taken place because of other reason, your lordship. But that was, my relatives brought some cash amount. So they went and they told me that you send me bank draft. Accordingly, I have told my office staff to make bank draft of that amount. My office staff has made that bank draft officially. If we are making officially, then in that case, we are not required to pay bank commission, my lord, bank draft commission. When I came to know that commission has not been given because it was my individual, then it was subsequently paid. Then I transferred out from the state of Arunachal Pradesh.
On that allegation?
Not that allegation, in usual course. I was suspended also. So normal, because I belong to UT cadre also, Arunachal Pradesh, Mizoram, Goa and Union Territory. So now I'm posted at Puducherry. So at that time, Ministry of Home Affairs thereafter initiated disciplinary proceeding against me. That was challenged before Learned Cat Delhi Principal Bench. Learned Cat Delhi in the year 2018 quashed the proceeding that Ministry of Home Affairs is not a competent authority. It is the state of Arunachal Pradesh, because incident took place in the state of Arunachal Pradesh and she was working with the affairs of the state of Arunachal Pradesh. That was quashed by Learned Cat. At the same time, one FIR was also registered in the year 2011, but not against me, against my staff, office staff. Matter was going on, your lordship. When my lord 2018, Learned Cat has quashed the proceeding, MHA initiated proceeding against me, saying state of Ministry of Home Affairs, saying that state of Arunachal Pradesh, the FIR which was registered in 2011, please send it to us. And that FIR was sent by state of Arunachal Pradesh. When boss is saying they have to send, then that FIR was sent to CBI. CBI registered FIR. This is violation of section 17A that I will show, my lord. Thereafter, they approached Honorable Delhi High Court, my lord, against CAT order. Delhi High Court, since 6 years, no order except issuing notice. Stay was rejected by Delhi High Court. 2021 thereafter, my lord, they started proceeding against me. Thereafter, charge sheet has been filed before this here, my lord, UPA court, CBI court. For my lord, So, because I am an officer of All India Service, Your Lordship, when I am posted in the state of Arunachal Pradesh, it's a full-fledged state. So, at that time, like in Assam, my lord, my disciplinary authority is Honorable CM, not MHA. So, prosecution sanction was initiated by MHA. MHA has granted prosecution sanction also. This is violation of section 19 of PC Act. The prosecution sanction which was granted by MHA is without authority of law. It is granted by incompetent authority. Thereby it is nullest in the eye of law. My lord, against me, apart from PC Act, my lord, sections of my lord IPC are also being leveled. For that, my lord, no prosecution sanction has been granted. I learned court, my lord, trial court has taken cognizance against me. So I am challenging, my lord, first transferring, I'm not saying FIR, in fact, FIR does not disclose any cognizable offense.
That was against the staff.
Staff, not against me. Charge sheet, prosecution sanction granted by MHA because it is given by a authority that I will show, my lord, who is not competent. And my lord, order taking cognizance by learned court bill. Now I am coming to your lordship first to apprise your lordship how it is judgment.
But he has something to say, I believe.
Yes,
What?
Instruction.
Before my lord, submission to be
Instruction.
made by the counsel for the
Two times
petitioner.
given, my lord, earlier.
My lord, what happened in this case, it is a serious my lord, allegation against the my lord. My lord, after investigation, my lord, this has come. Thereafter, my lord, charge sheet has been filed, cognizance has been taken. Next,
Charge sheet is filed against her.
Against me, yes.
against my lord, she is the officer, deputy commissioner, being IAC. Serious offense has been committed by as per the charge sheet. Now, my lord, matter is pending before the trial court. Now, bulky petition has been filed, made CBI as well as the Union of India.
This is their document, my lord.
My lord, now, my lord, since matter is already pending before the trial court. Now, my lord, as per the instruction, the CBI and the other respondents wanted to file my lord, the detailed affidavit objecting this quashing applications, quashing petitions, my lord. There are certain things, my lord. Basically, 4 points has been raised by the petitioner. One is regarding the registration of the FIR, and another is regarding filing of the charge sheet, my lord. And third is my lord, the prosecution sanction. The prosecution sanction he is rightly pointed out. And another my lord, is taking cognizance by the learned court below. My lord, altogether on 4 grounds he has filed this criminal petitions for quashing. Now, my lord, the FIR, my lord, as per the Honorable Supreme Court, when FIR is received, my lord, the FIR has to be registered. So unearth the truth of the case, my lord. That is, my lord, there is no requirement, my lord, to argue my lord, detail on the FIR is to set the law on motion, my lord. FIR has to be filed, my lord. Therefore, this detailed charge sheet has come up. Now another my lord, charge sheet. In the charge sheet, my lord, the entire things has been given, my lord. So we wanted to demonstrate, we wanted to file my lord, the affidavit by showing the my lord, the how justified the FIR is. And third, my lord, prosecution sanction. My lord, CBI is not such a ordinary investigation authorities to my lord, obtain the prosecution sanction from the persons who is not having at all my lord, the jurisdictions to issue such my lord, prosecution sanction, my lord. The detailed examination, detailed investigation, everything has been done as per the procedure, as per the law. Malad, sanction has been granted by the Ministry of Home Affairs, Malad, MHA.
That he has done.
Yes, Malad. So therefore, now Malad, he is challenging, Malad, I'm sorry, she is challenging that persecution sanctions given by the Ministry of Home Affairs is not in law, Malad. Not exactly, Malad. So I'll demonstrate that part also, madam.
That competent authority.
Yes, madam.
But central government employees
No,
have to.
yes,
yes.
No.
I will
Going
place
to
my.
those
Then we
documents.
wanted to file detailed affidavit, madam.
See, they have to be given a.
And
Yes, my lord. But till then, my lord, on 14 matter is fixed. Now we are going in vacation. Today the matter is fixed for interim consideration. Your lordship may kindly see order also. So proceeding against me,
Now,
my lord, directly, my lord, why I will face my lord trial, but on the basis of the prosecution sanction given by my lord, the person who is not competent, my lord, not authorized.
that will be, my lord, definitely examined.
Now, finally, your lordship will examine, my lord. But till then,
Now, my lord, another.
I may be given, my lord. 6 weeks, 8 weeks, my lord. I have no problem.
Another problem is, my lord.
Today is the third time, my lord.
This accused petitioner is never appeared before the court, my lord. Only on one occasion when the charge sheet cognizance was taken. After that, malad, several times, malad, there are two other accused persons who is not before this honorable court. Even if malad, charging this, malad, FIR is quashed, even if malad, charging this quashed, even if lordship interferes, the malad, cognizance malad, will be malad, the having malad, the bearing effect on the other two accused persons. Malad.
No.
Now, malad, other two accused person is not before your lordship. Malad. So they are the one, malad, this
Their
is
case is similar.
malad. So therefore, this is
My lord, they are state government employee. I am central government employee. They are different, my lord.
Regarding quashing of the FIR, my lord.
Yes.
The prayer for interim relief.
Yes.
Yeah. And then, of course, the
That day, that day also time was.
My difficulty is,
This way or that way,
CBI is heavy. Office Guwahati, not me, madam. Now another, that is one problem. Earlier, madam, the CBI was here.
Same question, my lord.
Now, madam, here.
Your lordship, can you stick
CBI
compilation?
Can you file it next week? Monday, Tuesday?
Madam, will try, madam.
My lord, it will not file, my lord. Vacation is there, my lord. We are also entitled
No,
to go.
before vacation, I'm
No, here, my lord, Guwahati, my lord, already, my lord. How can
And regarding, my lord, the
third time, your lordship, my lord, third time.
establishment of
This
CBI,
is not.
my lord, his lordship, my lord, the AI answering,
My lord,
and the division
my lord,
in Navi,
Supreme Court
that is
decision.
case, my lord. CBI has, establishment of the CBI is not correct, my lord. That challenge, my lord.
Oh, that is there?
Yes, that.
What happened to that?
My lord, that
Pending.
matter is pending before the Supreme Court.
Supreme Court has stayed Honorable Justice that division bench judgment. A matter is still pending.
But that was stayed long back.
Long back.
Listen.
Nobody wants to hear that
pending.
case, your lordship.
It's still pending, my lord.
Very
It was
good,
passed by
very good
the-
reasoning has been
the
given
then-
by.
The then Honorable Chief
No,
Justice
nobody.
of India,
My lord,
my lord.
only one decision, your lordship can see. Page 1 of my compilation. If the yes,
We'll
sir.
do one thing. Let him file it with it on Monday, Tuesday. And if he doesn't file, then we'll take
Well,
up.
I am
the-
not here, your lordship.
Oh, you will not be able
My
to
lord,
come.
my lord, because of vacation, my lord.
Let him come.
My lord, I am going for
online,
vacation,
my
my lord. Sometime, my lord. We are also entitled to spend, my lord.
Yes, yes.
My lord.
My lord, you can appear
Judgment, my lord, page 6.
online also, my lord.
Online, my lord. I want always, my lord.
My lord,
And today there is another predicament that we are rising at 2:45.
That's why,
because
madam.
of the-
Your lordship may
and
reserve
whether
it.
Within this 45 minutes, you'll be able to finish.
My lord, 15 minutes, less than 15 minutes, 10 minutes I will take.
My lord, since my
Page
career is for
Page 6,
my lord,
para
tell it
14.
to me.
I am relying on
Instruction again.
my lord, it is concerned, my lord, on the court will not function on his only instruction, my lord.
Yes,
From the last
yes,
3
he's
times,
praying.
my lord, from last 3 times he has taken time, my lord. Of 14, the matter is fixed. The next week I am not here. My lord, till then your lordship may fix it any date. I don't think they will file by Tuesday. This is bulky petition. My London friend said, let
This
it be.
time you
My lord,
please think.
let
This
them
time,
file.
my lord, let us think for the filing of
My
the
satisfaction
petition.
also, my lord.
Next.
Nowadays, everything is, my lord, on YouTube, your lordship. For my satisfaction, your lordship may stay proceeding so far as I am concerned. My lord, directly hit Article 21, my lord.
One after another reason.
Page
He is
6.
not appearing before the trial court, my lord.
Well, this is
Two
not
accused.
why I will
Two
appear.
accused. Two
Why
accused.
I will appear.
Two
On the
accused
day-
person and time and again, my lord,
in
only
illegal
because of
proceeding, I will appear. I am before my lord to show that this is illegal proceeding. Para 14, 15, my lord.
my lord, I'll come with my affidavit. my lord.
Till then, your lordship, para clearly says, my lord, if the competent authority has not granted, this is affidavit compilation.
Acha, you have challenged the FIR, charge sheet, process
Yes.
section, and with
Order
the-
taking cognizance.
and cognizance.
Yes, ma'am.
You have challenged all.
Your lordship may rely upon a judgment, my lord, I have given, my lord. Page 6, my lord, can you see? My lord, Nazir Ahmad says, if work is required to be done in particular manner, it has to be done in that manner.
Not at all.
My lord, page 6, para 14, my lord.
Hmm.
First 13, your lord, kindly see. The appellant proceeded against the respondents under the Act. Section 5 of the Act provides for the procedure and powers, will give you, of the special judge. Section 19 of the Act mandates that no court shall take cognizance of offense punishable under the provisions specified except with the previous sanction of the authority specified therein. So, my lord, even assuming sanction has been given, which is by incompetent under section 19, but no sanction has been given under section 197 of CRPC, because only PC Act is not there, my lord, IPC is also. Next, paragraph. Ordinarily, the question as to whether a proper sanction has been accorded for prosecution of the accused person or not is a matter which should be dealt with at the stage of taking cognizance. But in a case of this nature, where the question is raised as to whether the authority granting the sanction was competent, therefore or not, at the stage of final arguments after the trial, the same may have to be considered having regard to the terms and conditions of service of the accused for the purpose of determination as to who could remove from his service. So, my lord, generally it should be challenged at the time of taking cognizance. That I have done here. Next paragraph. Grant of proper sanction by a competent authority is a sine qua non for taking cognizance of the offense. It is desirable that the question as regard the sanction may be determined at an early stage. Next judgment, my lord, page 12, one-page judgment of Honorable Apex Court. The appellant is being prosecuted under the provisions of the Prevention of Corruption Act. The High Court refused to entertain the plea of lack of sanction for prosecution by the competent authority on the ground that it would tantamount to review of the earlier order, and the court does not propose to the power to review the earlier order. Under section 19 of the Act, no court take cognizance of an offense punishable under section so alleged to have been committed by a public servant, except with the previous sanction of authority competent to remove the persons concerned. In the case in hand, the Secretary Vigilance appears to have accorded sanction to prosecute. The appellant's case is that Secretary Vigilance was authorized to grant sanction only on ITNA, and there is no order of the state government making so-and-so to competent to accord sanction prior to the said date. The so-and-so, therefore it was quashed, my lord. Another decision, my lord. That decision I have shown your lordship. Same case happened in the state of Arunachal Pradesh, in the case of Hujur Laran, page 13, my lord. Here the case was, my lord, I was an IS officer, my lord, page my lord, 13. I was an IS officer, your lordship, like
Page 31.
13. It another bench of this honorable court. I am just summarize it, my lord, because facts are different. I was an IS officer, my lord. Investigation.
In this case.
Yes, my lord. Investigation was initiated against me. Thereafter, police filed charge sheet. Thereafter, Ashok Kumar Agarwal, page 47, my lord. And I'm taking your lordship directly to relevant para 70. It starts on 76, page 108. How the prosecution sanction should be given, Delhi High Court dealt with. In view of the aforestated facts, it becomes crystal clear that the entire record of investigation, including documents and statements of witnesses, and under section 161 and 164 of the code, as well as the case diaries, were not placed before the sanctioning authority in order for it to apply its mind before grant of sanction, that order dated so-and-so, and the said sanction order was passed only on the basis of SP's report dated so-and-so. In the first instance, it said the covering letter to the SP's report so-and-so is testament to the fact that the record of investigation is so and so was not sent to the sanctioning authority. Ma'am, thereafter, Honorable Delhi High Court dealt with, my lord, what are the requirement and all. And para 97, my lord, page 114. No, here 18 years, my lord, I am facing. This 2011 FIR, Department of Proceeding 8. I will show, my lord, CAT order also. Normally, the case would have been remitted back to the sanctioning authority for reconsideration on fresh order of sanction. However, in the circumstances that the instance case commenced as far back in 1998, 18 years have been since lapsed. And in the light of the decision of Honorable Apex Court in so and so, in my opinion, it would not be fair, unjust, and contrary to the interest of justice to expose the petitioner to another round of litigation and keep on trial for indefinitely on long period. It would also offend the principle answering in the provisions of Article 21 of the Constitution of India. A quietus must be applied to the present proceeding. Thus, in the interest of justice, finality is given to this proceeding, and it is directed that no further proceedings in relation to the subject sanctions order be initiated against the petitioner. My lord, in Telangana also, my lord, page 115, my lord Justice Ujjal Bhuya has delivered judgment. Same issue was there, my lord. My lord, like in Assam, if I am posted in Assam, so I am employee of Assam, officer of Assam.
But show me the PCF section 19.
PCF, your lordships. PCF and CRPC 197.
197 is there. PCF what?
First, your lordship, kindly see section 17A. Capital A, my lord. My lord, it is page 28. Bottom, my lord.
Yes.
Inquiry or investigation of offense relatable to the recommendation made or decision taken by public servant in the discharge of official functions or duties. No police officer shall conduct any inquiry or investigation into any offense alleged to have been committed by public servant under this act, where the alleged offense is related to any recommendation made or decision taken by such public servant in discharge of his official functions or duties without previous approval in case of a person who is or was employed at the time when the offense was alleged to have been committed in connection with the affairs of union or that government, my lord, kindly note it. That government. Because I was discharging my duties to the state of Arunachal Pradesh. In case of a person who is or was employed at the time when the offense was alleged to have been committed in connection with the affairs of a state of that government. Now, your lordship may kindly see allocation of business rules of Arunachal Pradesh. My additional affidavit, ma'am.
F of that government means the central government.
My lord, I am discharging of that government where I am discharging my duty. Your lordship may kindly see.
In the case of a person who is or was employed at the time when the offense was alleged to have been committed in connection with affairs of the union of that government.
Second, my lord. In case of a person who is or was employed at the time of when the offense was alleged to have been committed in connection with affairs of a state government. Because it is not applicable here because I am not working under union at that time. I was working deputy commissioner under the state of Arunachal Pradesh. So second clause B will be applicable in my case. And my lord, page 476 of my additional affidavit, my lord, kindly see.
Okay, it's 1 now. I'll come back at 2 again. Then.
My lord, this is combo of service and criminal, your lords, this case.
But he has also a point that he wants some time to file.
My lord, we have, your lordship may give.
You will be able to answer him today.
Yes.
Answer to his allegation.
My lord, without having affidavit, my lord, making some, my lord, submission is also, my lord, prejudicial.
That's why intrigue today
No,
only
my lord,
for intrigue.
even if, my lord, why, my lord, affidavit is required, my lord, whatever he has already made submission, that, my lord, I have the answer. Regarding
not appeared before the inspector.
My lord, cognizance has been taken. Appear means my counsel is taking time. That right I have. And in the meantime, I have challenged before this honorable court, my lord. Why, my lord, when Article 21 is there, my lord? When the trial has been proceeding on the basis of prosecution sanction given by incompetent authority, my lord, why I should face, my lord? That's why this
No, this sanction can be at any stage of the trial also.
Yes, ma'am.
If there is any
Exactly,
doubt
they can
as to
exactly,
whether,
ma'am.
yes.
My lord, cat judgment I will show, my lord. Cat has written in such a way why MHA is so interested against the petition. I will show, my lord, judgment.
That is
Though they are connected.
Prosecution sanction can be at any stage.
Exactly.
But by the competent authority, my lord, not by the authority who is not competent.
Competent authority, that is no.
I'm not saying prosecution sanction. I'm saying the authority who has given, he is not authorized, he is not competent. He has trench open power given to state of Arunachal Pradesh. I'm saying this, my lord.
Whether you'll be able to reply to his arguments today.
Arguments, my lord, as I have already pointed out, my lord, that having the clear instruction by way of affidavit, my lord, that will be prejudiced.
Mr. Goel, do it next week now.
I'm not, my lord, already.
Or it's
My lord,
done
14
in-
matter is fixed, my lord. Till 14, your lordship may.
14, you take time, the matter is pending before this court.
If your lordship observe, then it is easier, my lord. They will, my lord.
No, they will not object. You
My
take
lord,
time.
that's observation may be given for my statement. My lord, we are also taking material instruction, my lord. We have to show to client also. Yes, something I have taken.
My lord, let her appear on 14.
No,
Next time, my
where
lord,
is the
we'll
question?
put
I am
them-
in Secretary Pondicherry. I will not appear.
You appear through your advocate and
Advocate is appearing.
Huh.
They want me. Why they want me, I don't know.
Advocate can appear, there are provisions.
My lord may observe it. Your lordship.
Trial stage, my lord. Dispense application can be filed on this, my lord, but
I am not on why I will file, my lord. If
See,
your lordship
this
will
is the
hear,
problem.
if your lordship will, my
But
lord,
this is the
they
exact
will punish me. I will say, okay, you do it. This is they are saying, my lord, the entire I will show the allegation also, my lord. This is nothing but my lord Bhajan Lal says,
I understand, but then he also has to
my
have
lord,
his opportunity.
twice, my lord. Your lordship will see my position also. Twice he has taken
my lord,
time.
everything will be clear by way of
My lord, by way of affidavit.
Last time you had not taken time for filing an affidavit.
Yes.
My lord,
No,
only for the instruction, my lord. The instruction come, my lord, with
Twice, my lord, time was taken.
Oh, he could not obtain the instruction.
Yes, ma'am.
exactly, my lord. For the,
In 2 days, he will get the instruction.
Now you decide if
I
you
am,
are
my
not
lord.
able to reply today, then again prejudice will be caused. So let it be heard on immediately on reopening and on 14th. You file and dispense application.
That observation, my lord, that observation will be given.
That observation will
My
be
lord,
difficult for this.
amounting to stay of the my lord, the proceedings, my lord.
My lord, this is a case.
That is the only
my lord,
difficulty.
my lord, this is a case without hearing other side, your lordship, because the material and judgment which I have shown, I am or going to show. I will satisfy, my lord, that this is a case where stays must be granted, your lordship, without hearing them. Or whatever the document, this is their document. Their, in fact, agency is also not required. My lord, twice they have taken time, your lordship. This is not the.
We know that
My lord,
many times.
but my lord, I am coming, my lord, I have to show to that petitioner also that because nobody wants, my lord, that criminal trial should be hanged.
What do you want to show?
My lord, it is too early to show this paragraph. However, my lord, just for the ends of justice, my lord, may I take your lordship to the prayer made by the petitioner, wherein, my lord, that prejudice will cause to the other, the page 119, my lord. That is the whole reason I made this submission.
Your lordship will modify it. For me, for the petitioner.
My friend wanted to go Guwahati early, so let us fix the matter on some other day.
No. I want to. I am here for this matter.
Where is the period?
Yes.
In the premises, I proceed. It is there for respectful friend, your lordships would graciously be pleased to admit the criminal petition, call for the records and issue notices to the respondents to show cause as to why. First, as I pointed out, FIR. Second is charge sheet. Third one is prosecution section. And fourth is the taking cognizance of them. Fair to make submission, he barely
Left anything?
left that portion, if this FIR charge sheet is quashed, Madam, will having bearing effect on the other two accused persons. But it is not only in respect of him, Madam. So therefore, Madam.
So for them, I should go to court and I should appear for them. For other persons,
No, Madam, it is nowhere it is in respect
I don't know.
of her only, Madam.
They are not going to fight. My lord.
Impugned FIR qua the petitioner.
Yes.
That's it.
No,
This
Madam.
is the system.
FIR cannot be quashed,
Why?
Madam, in respect of her only, Madam.
Yes. So many FIR. I have
Charge sheet,
shown.
Madam, in
My
charge
lord,
sheet
may
cannot
kindly
be-
see Anurag Agrawala case. So many cases FIR.
Charge sheet cannot be quashed in respect of him. Cognizance cannot be, no, Madam. Ministry of is, Madam, something different.
No, my lord.
Because this is
Wrong submission has been made, my lord. It can be. Your lordship may stay the proceeding. He is not going to file, my lord.
No, he will file. He is a responsible authority.
Yes, but
He means CBI.
representing-
CBI, my lord. Bhajan Lal says malified inquiry investigation should be quashed. Para 101. This is the that FIR which needs to be quashed and heavy cost should be imposed upon CBI.
There's it's already 110.
My lord.
45, it's rising.
My lord.
So I don't think so. The matter will be finished. So, Mr. Goel,
My lord.
do it on 21st. Do it on 21st of July.
My lord.
Okay. And on 14th, you make an application before the trial court and say that this matter is pending to wait.
Your lordship may make it parted, my lord. Your lordship has heard at length, my lord.
But I may not come again on 21st.
DC, my lord. It is easier for me. I will appear there, my lord. For now, some trouble should be given to him also, my lord. I will appear there, my lord. Your lordship substantially heard. It is not, I am not saying for the sake of saying.
Interim what?
No, my lord, for final also. Your lordship may make it parted, my lord. On that day, Guwahati, he will appear from here.
Madam,
No
let him
problem.
go happily today. We'll question him next.
I'll pass the order. 21st, you do it.
Fine.
Whatever is there, if I come, I will take it. It depends on the roster. I don't know. Our roster
My lord,
is not-
that's why my lord, Guwahati, your lordship will be there. If my lord is here, I will come. If Guwahati, I will
It's
appear
okay,
there.
it's okay.
My lord, kindly make it. This is my request, my lord.
I'll-
Fine.
I'll-
My deeply obliged, man. I bow down, man.
May I please, my lord?
Yes.
My lord, item 24.
Item 24.
Yes, hearing item. This matter will take some times.
Ah.
So this matter will fix on Monday.
Okay. As prayed for by Mr.
G. Tarak,
G. Tara, appearing for the respondent.
respondent, yes.
Paying for the respondent. List the matter. You have.
Yes, I have
taken
communicated.
consent. You have
Yes,
informed.
yes.
List the matter after 2 weeks.
The Monday.
Oh, on Monday?
Yes.
Okay, list the matter on 30th.
30th
30th of June 2025.
Obliged.
Item number 9. Yes, 9. Go to Fupan. Petitioner is not there.
Petitioner is not there, lawsuit.
On the last occasion, what happened? Oh, then also nobody appeared.
Yes, lawsuit.
Huh?
They are not appearing, lawsuit. They have,
No one appears.
yes, lawsuit. They have seek permission to file some affidavit, lawsuit.
Huh. They were directed to file affidavit?
Yes, lawsuit.
Praise for 1 week to file affidavit.
Yes, lawsuit.
Okay.
I think record has also come, lawsuit, in this regard.
Huh. This is a 482 inherent power.
Yes, lawsuit.
Petition on the inherent
Yes,
power.
lawsuit.
If he does not come on the next day, we can dismiss it for default.
Yes, lawsuit, because trial is going on, lawsuit.
Last opportunity.
Yes, lawsuit.
None appears for it when the matter is called up. The applicant, the petitioner, the counsel, Mr. Gautam Fukan, appearing for appearing for the petitioner, is not present before the court. It is seen from the earlier orders. It is seen from the earlier orders too that he has not appeared on many occasions. This is a criminal petition filed by the petitioner for invoking the inherent power of this court for quashing of the FIR charge sheet, everything.
Yes, Lordship.
For quashing of the
Yes,
FIR,
yes.
charge sheet, as well as the subsequent proceedings, which are pending before the learned JMFC UPR. Full stop. A last opportunity is given. What did I say? No, before that, this is so and so, and then for the petitioner, for the counsel to appear before this court. Otherwise, necessary process would follow. List is up to 2 weeks. I know Mr. Gautam Fukan, he comes to the Guwahati right. They are present, write their names.
He's for respond number 2.
So it's for respond number 2 and the learned APP are present.
My place, madam.
Yes.
I know the respondent were supposed to file the affidavit, madam. The respondent were supposed to file their affidavit. madam.
Not yet filed
Not
affidavit
yet.
on behalf of sole respondent.
Sole respondent.
You have taken time on a number of occasions. Heard so and so, Mr. So and so,
M. Ratan.
and yes, Mr. N.
M. Ratan, madam.
Your name is there.
My name is there in Wakalat nama, madam. But in consolidation is not reflected.
Achha. So and so submits prays before this court that he may be allowed some more time to file the affidavit, more time to file. This is a criminal case.
Yes, madam. For quashing, madam. Setting aside, madam.
This is item.
RFA, madam.
This is RFA. Yes, affidavit in opposition. It is seen from the records that he has taken time on the said aspect a number of times before. As such, it is directed that he may file his affidavit on the next date positively. List this matter after 2 weeks.
Interim is there, madam.
Interim passed earlier shall continue till the next date.
DBW.
You file it. You have taken 4 times.
Yes, ma'am.
4 numbers of times you have taken adjournment. This is that election matter that you were saying.
My lord, this is student election matter. My lord,
And there is another analogous matter.
yes, my lord, which is listed in order, item number
20, item 20. madam.
20.
Yes, sir.
Item 20.
20.
This
So 20 and this one can be taken up together.
together.
Can be taken up together.
This will take some time, I think.
It will take some time.
Can you finish it?
At least, my lord, I'll take 30 minutes to 45.
Okay, then he will take. So matter has to be again left parted then for the next week.
Yes, it can be on, yes, next week's third, we have agreed on third half, today, second, right? So today half part can be done.
Okay.
Yes. Well, this appeal.
This is civil.
Yes, first appeal against the order.
Hmm.
Against the other order 43, rule 1, 3. Read with section 151 of the Code of Civil Procedure. Here, before coming to the impugned order, my lord, just some relevant facts I want to give. The union, this is a student body union. This is a federal unit of APSU. APSU is a all Arunachal Pradesh student union for the entire state. And this particular union, this is called All Kurung Kume Karadadi District Student Union. This is a
All?
Kurung
It's written
Kume-
somewhere.
Yes, the last one.
All?
Kurung Kume
Oh,
Karadadi.
Kurung Kume.
This
Okay.
is a district.
This is a
Districts.
district.
Two districts, Kurung Kume and Karadadi.
Kurung and Kume are two
Oh, sorry,
different
sorry.
districts.
One district. Kurung Kume.
Kurung Kume.
Yes.
So, okay. Huh.
This is a student body, which is a unit of the federal unit of the APSU.
Federal unit of the
Federal
APSU.
unit of APSU. Means in each district, there is a branch, district unit.
Okay.
So this is one of the
A
districts.
federal unit of what you say?
APSU. All Arunachal Pradesh Student Union. Like
all Arunachal Pradesh?
Student Union.
Oh, what?
Like all Assam Student Union.
ASU.
It's the same like.
ASU type.
Yes, ASU type.
Mm.
So it's a federal unit. It has its own bylaw, bylaw prescribing how the election to be held, what are the powers, function, who will hold the election. Everything are there in the bylaw. This is basically a completely a union, even it is not a registered union. This is a sort of like a pressure group sort of thing. So, following the expiry of the earlier tenure, election was held. All this notification, everything were issued as per the bylaws. These are admitted fact. All things. Then pursuant to there, then the requirement is that first Chief Election Commissioner, then Chief Election Commissioner, returning officer, then polling officer, presiding officer, those were also appointed. Those were the pro forma respondent hearing, 3 to 6. So in exercise of that power, they issued notification. First stage is registration of the delegates, means voters, those who will vote. Pursuant to the notification, as many as 1,071 voters, they got themselves registered. Then subsequent is that the filing of the nomination, that nomination has to. So what happened at the time of filing nomination, as many as 30 something like they filed the nomination. But what happened? None of the rival contender filed the nomination paper.
There were many posts for that.
Yes, executive posts as many as more than 30. So we here appellants are 27. Some have not joined. They have taken side of the other party. So 27s are the appellant here. Those who are agreed by this impugned order. They filed the nomination. Then Chief Election Commission is accepted nomination. And they waited
37 of them filed
for
nomination.
27.
27.
Along with others also.
Ah.
Including the plaintiff, number 1 here. He also filed the nomination. And this plaintiff number 2, he did not file nomination, but he enrolled himself as a enrollment list as a candidate for a post. Then, when there was no any rival contenders,
Unopposed.
yes, all the executive posts.
Ah.
Then Chief Election Commission issued the election list.
How many executive posts?
My lord, I will come here.
They were declared elected, all of them.
Yes, my lord, I will come. Enrollment list and
Perhaps it's there in the pleadings.
my lord, this is all there in the pleading. my lord will find.
1 to 27 were declared elected unopposed.
My lord will find page number 185 to 183. D for this election result 28/9/2024. This election result was issued, my lord. Page 185 to 189.
All the 27 posts.
Yes, my lord. One day.
Yes, 185
It
till
starts from 185, my lord. And my lord will find total
10.
Uh,
What happened?
26, 27, 28, 29, 30, 31. All together 31. Including some women wings posts were also there. From
I find here in page number 85.
185, my lord. Starts from 185.
Yes.
Uh,
So following candidates are hereby declared as executive members.
Yes. May I take here, my lord, this?
There are 10.
My lord, page number 185.
There are 10 here, elected unopposed. Then
No,
again, next.
no, next, my lord, this is a type copy. Then, my lord, 187.
Oh, achha.
Then 26 total.
26.
Then, my lord will find at page number 189. This has to be added also.
189.
Page number 189.
There are
26,
5.
27, 28, 29, 30, 31. All together 31.
No, that more than what happened. I mean, 185, it talks of 10 persons.
No, thereafter 187 continues.
Oh, achha. This is a continuation.
Continuation.
So 26.
26 plus 27, 28, 29, 30, 31.
31.
31.
Okay.
My lord, kindly again look at, take the page number 185, my lord.
1 second. 185.
My lord, serial number 5.
Hmm.
This is the plaintiff number 1.
Achha.
Since he filed the nomination, he was declared elected. My lord, kindly see, post is Assistant General Secretary Protocol. He applied for that post. He has been declared elected.
Yes. Okay.
Now, my lord, thereafter, kindly turn to page number 187.
Yes.
Serial number 14. This is Ngurung Tugung. This is plaintiff number 2. Although he did not apply, he did not file the nomination, but he got himself enrolled in the candidature enrollment list. Therefore, Chief Election Commissioner thought, since nobody has filed nomination for this particular post,
That is again will not be legal.
that's why, my lord. This 14,
14.
serial number.
As far as 14.
But Chief Commissioner thought, declare him. He has been declared
Unopposed. Okay.
unopposed. Because keeping this post vacant, no use, then he has been declared also. Now, these two, plaintiff number 1 and 2, they have been declared elected unopposed. Now, what these two thereafter,
All are declared elected
yes,
unopposed.
my lord. Then these two plaintiff, my lord, they files the title suit,
Oh.
saying that no election was held.
So surprising.
So surprising, my lord. And this petition itself is not maintainable, my lord. Now, what is the right that has been infringed? Now, he said
Not
that,
an aggrieved person.
yes, my lord. This was my whole contention, that this petition itself is not maintainable. Now, what is there in the plaint, my lord, is that right to contest election. So, who has denied him not to contest election? Rather, he has been declared elected in the absence of any rival candidate.
Between.
My lord, because somebody has to be there to contest the election, my lord. Now, these two person files the petition. Now, very interesting, my lord. The learned trial court below entertains the title suit. The ground of filing is that no election, and for interim injunction, false misleading statement was made. I will show why I am saying like that. The first ground given is that APSU has not recognized our election for seeking the temporary injunction. Then another ground was given that APSU has not recognized our these things and their growing age. So there is a urgency for holding elections since there was no election. This was the case. Now, very interesting, my lord. We filed caveat on 39/2024, apprehending that this election result will be put to challenge. We filed that. It is on the record on 39. Now, this title suit along with miscase was taken up on 110, next day.
1/8.
110.
110
Yes, madam.
of 24.
24, madam. Then on that day, my lord,
The impugned order.
first, that I will come slowly, madam. On that day, first ad interim order was passed, madam. Annex 6, no, is number.
Ad interim injunction.
Ad interim injunction order. Now,
Where is that?
my lord, I am coming. Annex 6.
Without hearing, caveat is there.
My lord. Without
But,
hearing.
but in certain cases, if some urgency without hearing the caveat, it can be done.
My lord, I have one judgment with me, my lord. It's saying our own High Court judgment is saying it's completely without jurisdiction. If this caveat is not discharged.
But I think I've seen that judgment sometimes in certain circumstances.
My lord, that maybe also, my lord. But as of now, my lord, some judgment of Madras High Court was there where that view was taken. But our own court has disagreed to take that view. Sir, I will place the judgment.
Where is that order?
My lord, first I will take the ad interim order, no? Kindly turn to page number 142, 148, ma'am.
42.
Madam, 1/10/2020.
This is the miscase. Okay.
Yes, my lord. Miscase 42, my lord. This judgment, this ad interim, it needs to be, my lord, read thoroughly. Why, my lord? Because subsequently, the order which is being challenged right now, my lord, that this ad interim order has been made absolute without again hearing me and without discussing any of the pleas raised by me. And just says that taking some another issue, they say that this ad interim order has been made absolute. So now that's why, what was this ad interim order? What was the reason, my lord? I'll just take, my lord, to page number 146, my lord. At the bottom, my lord. May I read, my lord?
Yes, after hearing.
After hearing the learned counsel for the plaintiff's petitioner and perusal of the post record, I found a prima facie case that the so-and-so was not allowed to conduct by the learned Deputy Commissioner Capital as well as learned Deputy Commissioner of Kurungkame District Coloring by prohibiting the defendant respondent number Chief Election Commissioner so-and-so. But despite prohibition order, the defendant respondent number Chief Election Commissioner issued another notification on dated for conducting election so-and-so. From the record,
Prohibition order.
that's why, my lord. That was at the first. I produced a letter whereby this prohibition letter has been superseded, my lord. And this fact has not been taken. It's on the record. I have taken that way, but not taken into consideration those things. Then thereafter, from the record, there is nothing to show that the election was conducted in pursuant to the said notification issued by the defendant. Rather, there is a cancellation or prohibition order passed by the learned Deputy Commissioner with a direction to the Superintendent of Police Coloring to execute and implement the same. Therefore, I am of the considered view that a prima facie case has been made out against the impugned and undated declaration of result, which is further clear from the instant suit itself, as the instant case had been filed by the plaintiff who also have been declared as elected unopposed in the impugned so-and-so, my lord. Now, learned tribunal is saying that the plaintiffs, they themselves are the elected candidate, my lord. In view of the above, the balance of convenience also lie with the plaintiff, considering the submission that the impugned number dated so-and-so has not been accepted and recognized by student body APSU as on today. My lord, that's why I said there are two grounds. First, there was a prohibition letter of deputy commissioner. Second, that APSU had not recognized the election. These two grounds were refuted by me by bringing on the record, the relevant record, saying that the deputy commissioner has revoked its own order, allowing us to continue the election. Thereafter, election was held. APSU later on APSU, because APSU initially, only because APSU did not recognize initially, because one of the plaintiff in that item number, he is a member of the APSU. Therefore, this issue is going on. Now, that plaintiff, he has been even banned for 6 years from participating in the APSU or election matters. There is the plaintiff in next, this item number related item. Now, my lord, is not suspended, they will be barred by their age to participate in the future elections. So and so. Now, another ground is given, reasoning, my lord. Age. Now, age means, my lord, we are of the contemporary age. This age factor will not be only applicable to the plaintiff, my lord. We are of the same contemporary age. It is equally applicable to us also. My lord. In view of that, I am inclined to grant so and so. Then this was statement. Election result was state. Now, immediately after this stay of this election result, my lord, immediately the defendants, they file written statement without taking time, my lord. They brought on record that by suppressing the fact, especially that about the deputy commissioner, subsequent revocation has not been brought on record. APSU's subsequent recognition has not been brought on record. Defendants filed the relevant material, written statement, everything.
Where is that written statement?
Written statement, my lord, will find Annexure 7, page, it starts from page 149 onwards, ma'am. This is defendant number 1, 2, 3, and 4 from the pro forma. The defendant, those are the officials who conducted the election. Then my lord, I will just take straightly to the annexures, my lord. My lord, kindly turn to page number 169. Yes, ma'am. Yes, 1,074 delegates got themselves registered.
169.
169, my lord.
Okay.
My lord.
The voters.
Yes, my lord, voters. Now, my lord, kindly turn to page 170. Next page, my lord. My lord will find type copy at page number 171, my lord. This is the, my lord, candidate enrollment list, my lord. Under the bylaw, if any candidate aspires to contest the election, first he needs to get himself enrolled. So this is the enrollment list. So my lord will find at serial number 10 is the plaintiff number 1.
Serial number 10.
My lord.
Okay.
And serial number intending to contest the election, my lord. Thereafter, my lord will find this order. My lord, the important document, page number 184.
184.
This is order dated 27, issued by the deputy commissioner, revoking the order.
Of prohibition.
Yes, my lord, which was relied by the learned trial court to grant the injunction, my lord.
Just read it once.
My lord, from the third paragraph, my lord. And whereas after threadbare discussion during the marathon meeting, all the stakeholders of the upcoming general election so and so fully assured to maintain peace, order, and tranquility, and if in case of holding of the aforesaid event. Therefore, the order number so and so and passed by the stands immediate effect. Then, my lord, page number 185, this is the result.
Prohibition was due to breach of law and order.
Initially. And there after that, my lord, there was a meeting. And in the meeting, even these plaintiffs were present. Their endorsement is there. Then when that matter was resolved, then allowed to proceed further with the election. Then my lord kindly turn to page number 191. This is a newspaper, my lord, where declaration of result was published.
191.
Yes, my lord. Then, my lord.
This is paper publication.
Yes, my lord. Result was published for wide publication. My lord. Then, my lord, kindly page number 194, my lord. This is the intimation letter given by the Chief Election Commissioner to the President APSU, to the central unit, informing that election was successfully held. My lord, thereafter, my lord, page number 195. This is an oath-taking ceremony. This was also done before the passing of the injunction order. This all. Then, my lord, kindly turn to page number 198. These are the nomination papers filed by the candidates. Those are of all these candidates, including of the appellants.
Including the plaintiffs.
Yes, my lord, plaintiffs nomination, my lord, will find at page number 205.
No, I think it's a settled proposition. Who can knock the door of the court?
My lord,
The aggrieved person.
yes, my lord, no locus standi, my lord. Apart from that, also I am raising another issue, my lord. Even if I concede, they have a right, even then, no prima facie case has been made out. Even if I concede that they have a locus even, my lord. That balance of convenience, everything is in my favor only, my lord. Then, my lord, 205 page number is the nomination filed by the plaintiff number 1. But so far, plaintiff number 2, as I have submitted, my lord, that since he has not filed nomination paper, but he got himself enrolled, that's why we gave him.
Yes.
And giving him the post, how this will adversely, if he doesn't want to continue, you don't join the union. No issue. Then my lord, this is next is page number 256. This is very important. This is the order where the APSU has recognized.
Page?
Page number 256, my lord.
256.
My lord.
Yes, this is what?
Because learned trial court says that APSU did not recognize. So these letters on 8/12/2024.
They have
yes, my lord. I will just read these things. From the bottom, the second paragraph. Therefore, by the powers vested in the President under so and so, the undersigned hereby revoke the order dated due to the complaint party taking the matter to the court. However, APSU will respect and honor the verdict of the court in the matter will act accordingly. So, earlier order was 2/10/2024, by which we were not given that recognition.
No, but then here, where is the part where they have recognized the election?
My lord, I'll just come here. I will start from the top reading. Where it has been observed that the district is currently entangled in internal conflict and dispute which have been brought before the court, making the matter sub judice and creating confusion and ambiguity within the district. And whereas the representation was submitted to the office of President for the solution of the matter, following which a committee was so and so. Whereas the matter was brought before the court by the complaint party right after the constitution of the committee for peaceful committee, making it difficult for the committee to execute its duty. And whereas the chairman of the committee considered for peaceful has submitted the matter has become sub judice and making it difficult to undertake further course of. And whereas it is crucial to ensure the continuity of student activism and leadership within the Kurungkume district. My lord, being a federal unit officer for the welfare and interests of the student of the district. Now, emphasizing that allowing them to is very important. Therefore, by powers vested so and so, the undersigned hereby revoke the order dated, my lord. This order dated 2/10/2024 was the order whereby we were suspended not to carry out any activities. Meaning thereby once that revocation is given, from that this paragraph, it is clear that
But this will be again implied.
my lord, by reading, because yes, my lord, because it is something like that, my lord. There is no such requirement that formally recognition APSU has to give. No, there is no such recognition is there. But APSU, it shows like even that is
But
subject
that will be in their own constitution.
on constitution. There is no such thing that in every election first APSU has to recognize. No, there is no such requirement. Here what happens is once election was held, you intimated, that is enough. That intimation enough. In our case, what happened when intimation was given? Then, since the plaintiff in item number 20, he assaulted physically. Their contention that not recognized, that is also not there. Even if I say APSU has not recognized, for example, for the sake of argument, then another case where the bylaw says that unless an APSU doesn't recognize, that is formally recognized, I cannot function. That is not the requirement at all, my lord. Even if I argue for the sake of argument, my lord. Now, hereafter, my lord, then my lord will see page 313. Because these facts are important. Thereafter, I will straightly come to the appeal and grounds of appeal I will address. Page 313, my lord.
And where is that where DC has revoked the prohibition order?
My lord, I have just shown here.
I forgot which one.
Yes, yes, my lord. I'll show here again. My lord, kindly turn to page number 184.
184.
My lord.
Oh, I've marked.
My lord, my lord.
184.
184.
I've seen. Yes,
Right.
sorry. 184. Okay. Then 131, you wanted to show something?
Then, my lord, I will come here.
313, I think.
Yes, my lord, 313. These all orders, my lord, I have annexed here from
These are the
till
orders.
page number 321, my lord. From 4/11/2024, my lord, ad interim was issued on 1/10/2024. Then from I appeared on 4/11/2024. I even filed my written statement and prayed that this miscase may be disposed of. My lord knows that when ad interim, my lord, 30 days at the most. And some exceptional circumstances may be extended for some time. But what happened in my case, my lord?
But that is gone, I think. Supreme Court has
My lord,
done away with
it is wrong.
30 days interim order.
My lord, that is a statutory requirement, my lord. But then, since 4/11/2024,
Appearing.
I repeatedly appeared and made repeated requests, kindly dispose the miscase, because this ad interim order is basically not affecting anybody, but affecting the defendants, who are the appellant here. Now, but my lord, all these days, for one reason or another reason, the matter was kept adjourning for almost from more than 8 months, my lord. Ad interim order was kept extending for more than 8 months. Then on last occasion, my lord, The impugn order, it was passed on 10/6/2025.
Okay, yes. 10/6, it was made absolute.
My lord, I will come now. From 1/11/2024, I appeared, my lord, from the record will see. I did not even take a, I repeatedly appeared, insisted for the at least consideration of the mistake. But all these days, not taken. On 10/6, the conducting council, personally, I am the conducting council there also. Yes, my lord. So on that day, for some unavoidable reason, I could not go. And I engaged one of my associates seeking adjournment for 1 day, single. Then, my lord, learned trial court impugn order, I will show that this matter has been pending since last 8 months. So it needs to be disposed of at the prayer of the council. Now, urgency is showing council, and my lord, this ad interim, neither I was heard, ad interim, and this impugn order, without hearing me and without assigning any reason, have made the interim order absolute. Now, I will come to the, my lord, it's a very, this thing unfortunate, my lord. Then I will come to this. Another, my lord, before coming to the impugn order, my lord, another important subsequent development I have to apprise this honorable court, my lord. My lord, page number 352.
352.
Annexure 12. Now, my lord, now this plaintiff number 1.
Yes.
He has been appointed to some another district union, my lord, which is called All Damin Parsi Parlo Panyang Student Union.
Oh.
He was appointed already president even, another district union. Now, what is his interest here?
Plaintiff 1.
Plaintiff number 1. This document. Now, my lord, I will take to the, my lord, impugn order, my lord. Page 26 onwards. This is the impugn order whereby ad interim order has been made absolute, my lord. And my lord will find no discussion, nothing. And all these things which are brought on the record, not highlighted, nothing, my lord. My lord, kindly turn to page 26, 10/6. My lord, kindly turn to page number 28. Even, my lord, before that, my lord, the recording about the council is contradictory. I will show. First, kindly turn to page number 27, my lord.
They are defendants number 1 to 5 are represented by their counsel.
My lord, page number 27, my lord. Page number 2, at the top, my lord. With regard to this case, so learned counsel for defendants, namely Binip Nyarus, this is my associate who went there to seek the adjournment on my behalf. And Duyu Chada have no objection, my lord. If the case is considered today, very interesting, my lord. I pause here, my lord, forever. Now, here it is recorded, no objection, my lord. Kindly turn to page number 28. This is, I have also, my lord, second para, I have also heard Mr. Binip Nyarus, and he prayed for adjournment of the matter, my lord. I sought for the adjournment of the matter, my lord. Now, my lord, let's see the reasoning from here onwards, my lord. Third para, my lord, upon hearing the parties' sides.
Yes.
Upon hearing all sides, I have perused the case records and found the ad interim injunction was passed on so and so, and the same is still maintained peacefully for around 8 months, my lord. He is saying that for 8 months, I have been keeping this ad interim order, although we tried our best, whatever we could do, since 1/2/2002, and no new development has occurred which would warrant alter so and so. Everything were brought on record why this aid interim was wrong. These are not maintainable. This plain itself is not maintainable. Title suit is not maintainable. But nothing will be discussed here. Now, moreover, order 39 so and so mandate that the court to dispose of aid interim order within 1 month of. But after 1 month, all of a sudden, with due respect to the learned trial court, with highly respect, my lord, that out of slumber, he all came to know, oh, now there is a mandate of 1 month. Out of slumber. with due respect, I have also heard learned counsel of both the side and also perused the case record and found that instant miss case is pending for 8 months due to non-appearance of the defendant respondents at initial stage. Now he is saying that non-appearance of the defendant respondent, my lord, he has to consider who is the aggrieved party. Some are there, those who are in favor of the plaintiff. Now the trial court is saying that first let them appear, those who are not aggrieved by. And these appellants, those who are aggrieved, immediately on the before next hearing day, we file all the written statement. Due to non-appearance at the end, and thereafter adjournment.
This is actually incorrect, non-appearance. We
My
are
lord.
appearing. Okay.
Yes. For white, then adjournment due to paucity on the. I have also minutely considered the facts and circumstances and considered a temporary injunction granted in while disposing the case. Now, very interesting. In title suit number 7 of 2025, my lord. Here I, my lord, need to elaborate a bit, my lord. This title suit 7, very interesting, my lord. This is item number 20. This item number, this title suit number 7, my lord, after the 8 months of the holding of the declaration of the election result, the item number 20, my lord, to again another person filed the case after 8 months of the declaration of the result on similar ground, saying that no election was held. And
They were also opposed, elected unopposed.
no. They did not get themselves enrolled in the enrollment list, number one. Second, they did not file any nomination because without nomination, how it can be? Now, even is that. Then what these 8 months, what prevented them from challenging the immediate this election result? They waited for 8 months. And one of the plaintiff there, he has been debarred, as I have submitted, my lord, for assaulting the members of the APSU. He's been debarred for 6 years. Now, even if his title suit is allowed, say that he will be allowed to, that is, it's only academic. What's purpose it will serve? He has been debarred altogether from taking part in the election activities, my lord. And that order is still invalid, my lord. There, very interesting. The plaintiff there also files the injunction order. First day, injunction was not given. Now, in that order, my lord, it is reflected that caveat was filed on 30/9/2010. 2024, my lord. I will take to that order, my lord. In this order, because already in 1/10/2024, my lord, already he has already granted an interim injunction, though caveat was there. But in this case, after 8 months, he is saying now, caveat is there, I will not grant an interim, but after hearing the parties. Then after hearing was done, then injunction was granted only on the one basis that there is already an interim order is existence in the title suit of 2024. Therefore, there is no harm in giving them another injunction order so that another injunction has been again gifted to the plaintiff. That has been put in the challenge in another FO, which is the item number 20, my lord. My lord, I will show his order, my lord, saying that caveat was pending there.
Here he did not write about caveat, right?
No, my lord. Here, my lord, nothing, my lord.
Then what? Absolute. Because
Yes, my lord.
already been passed in 7th, the one you said.
I 321. My lord will find page number 121, my lord. Okay, 121. starts from page 121 onwards. My lord will find order 8. Okay. 141. Kindly turn to my lord page number 140, my lord. 140, my lord.
121 is the caveat petition.
My lord, caveat petition.
Then what you said?
Page number 140, kindly turn to my lord.
140. Okay.
Starts from 139, it starts, my lord. When, my lord, after 8 months, another title suit was filed, 07.
Yeah, another 8 months from the date
Date of result, declaration of the election. After 8 months, all of a sudden, again, 2 persons come and file this title suit 7 of 2025.
Which is actually the issue here.
In item number 20. Why I am referring this order is to show that about caveat, my lord. Kindly turn to page number 139, my lord. Order dated 22/4/2025, my lord. And next page, my lord. Third paragraph, my lord. My lord, I carefully perused the case record. My lord has got third para.
Yes.
And found that ad interim injunction has already been granted in Miss case number so and so. It is also found that one caveat petition have already been filed by Mr. Babu Benga and another through his learned counsel Mr. so and so white caveat number dated 39/2024. And then ad interim he passes on 1/10/2024 and he makes absolute, and my lord has seen the order by which absolute has been, where my contention, my submission, my record, where it has been discussed. The ad interim was passed without hearing me.
This ad interim is in respect of the other case, right?
This in respect of other case. So on that day for this one not given. Saying that no, already there is a stay.
So it will not affect any parties and then.
Yes. So next time it's given. But my purpose of referring is to bring on record. It is admitted on record that there was a caveat before passing that first ad interim injunction. And that could not have been done at all. Or even, my lord, my intention was that I could have immediately challenged. But my intention, why I did not challenge, was that rather than going for technicality, I wanted to argue on merit. Otherwise, immediately I could have got vacation. I know 227 I could have invoked. Next day it could have been gone. But because of my good faith, I have suffered, my lord. I thought that since no case is there, rather than raising the technicality issue all about not heard, better I will go and hear me. I even made this submission to the learned trial court that I am not going, but I want that on merit you hear me. Because I have a good case, I know it. Because this is not a case where even maintainable, this is not a case. So this is basically all the relevant facts.
Yes.
Now I will come to my grounds, my lord. What are my grounds, my lord? First ground, my lord, is about maintainability. Oh, my lord's time. My lord, no issue. We can continue.
We will appear through online only.
My lord.
Okay. Then what do you want to
do? Now grounds of appeal. Just I will thereafter I will conclude this part. Or my lord, next time we can do. My lord has to go. No issue. My lord, no issue. We can continue next on second.
We'll start on Monday again. Otherwise, I'll forget.
Monday, my lord, I will be out of station.
Oh,
I have some matter.
With consent on second July. Wednesday. Sorry.
2nd June.
July.
It's almost concluded. Only, my lord, I will apprise grounds only. Thereafter, it's finished. And another that FA also it's connected matter. Only all things are same. Only I have to bring on that how they are not entitled to file the claim. That much only. Otherwise, it will be the same facts.
Okay. On Tuesday then. Tuesday, both of you can fill
No, Wednesday. Second is Wednesday.
Friday I'm going, so I want to deliver it before I leave. Don't want to take anything to Guwahati.
Tuesday it will
Do
be
it
not
on
possible.
Tuesday?
Tuesday it will be, I'll be on Cernil also.
Wednesday.
Wednesday also.
Lady, can it be taken as a first item for admission column?
Better.
Yes, my lord. My lord has heard all the thing, my lord. Only now grounds, 3 grounds, 4 grounds.
He said he will take around 45.
Let him argue.
You shorten it. Okay.
No, Lordship, because all the things I have to reply. Now, Lordship, only one side of story. That might be very interesting so far. But other side, Lordship, that needs to be also heard thoroughly. Because this is
Wednesday, you try to finish.
Wednesday, I'll try to finish.
Wednesday in the first half itself.
Huh.
Okay. Matter heard in part. And due to paucity of time, none not required. Matter heard in part.
Yes.
Listed again on Wednesday.
Deeply over.
As, Lordship, as a first item of.
Right.
As a first item in the admission column.
Right. Deeply.
Can I make a mention?
Highly obliged.
Lordship, item number 25, supplementary totally.
This.
Takes today, but because of paucity of time. So may I only say that this matter may be taken up on Tuesday.
Okay.
In addition.
Tuesday.
Yeah.
Okay. Tuesday again.
Yeah.
For admission.
Very small matter there.
For the disposal.
Yes.
Okay.
Only Lordship,
Listed.
I am for the
As
respondent.
paid for by
Yes,
sir.
I am for-
Listed on
Since
Tuesday.
everybody wants to get disposal from Lordship only.
I cannot handle so much. Okay.
Deeply obliged.
Madam, बाकी madam.